Okay, it looks like the folks joining us have kind of slowed to a trickle at this point. So we'll go ahead and get started. I just wanted to again welcome all of you. Thank you so much for joining us. I've seen already a ton of chats coming in from all around the state, so it's really, really exciting for all of us to be here together virtually. And we're just so happy to have you. Oh, by the way, my name is Elizabeth Well. If for those of you who don't know me, I am the legal director here at Ohio Crime Victim Justice Center. I'm going to give everyone else a chance to introduce themselves, and then we're just going to dive in because I know everyone is really, really excited to learn about all these new changes that are coming to our state here in the next couple months.
Good morning, everyone. My name is Latina Bailey. I'm a staff attorney and I work out of the Cleveland office.
Good morning. My name is Sierra Davis. I am one of the victims' rights advocates in our Columbus office, and I work primarily with our legal director, Elizabeth.
And good morning, everyone. My name is Bree Beach, and I am another one of the victims' rights advocates in our Columbus office. And like Elizabeth said, we are just so excited to have you all here. This is our first training following House Bill 343. And so we are just really excited to dive in and talk a little bit about all the new changes coming to you guys come April. So getting started with some of the logistics today, basically how to interact with us. So if you guys have any questions going forward, we really encourage you to use the Q&A option. In the back end, Sierra and Latina are going to be answering the questions, doing the polls, helping us back there. So any questions that you have, again, just please use the Q&A option, because as you see with the chat, there's a lot of people talking this morning, which is awesome, but we just don't want any of your questions to get lost. Also, just make sure that you are changing it from all panelists to all panelists and attendees. That way your question is going to be going to us, but also everyone else that's on the webinar today. Because I'm sure that some of your questions, they're probably going to have very similar questions as well. And yeah, Elizabeth is going to take it away.
All right, so for today's training and in all of our trainings, actually, we are approved for both continuing legal education credit as well as CEUs, or sometimes called CPEs if you're a counselor or social worker, or marriage and family therapist. I should throw that out there. So we will take care of the CLEs for you. We're going to have check-ins throughout the day today, where we're going to ask that if you're an attorney who's joining us and you want CLE credit, you put your name as well as your attorney registration number into the chat. And while we're on that topic, let's go ahead and just have our first check-in now. So if you're an attorney who is joining us today and you want CLE credits, please put your name and your attorney registration number into the chat for us, so that we can take care of those CLEs for you. For everyone else, if you're getting CEUs, you will have noticed when you registered an option to get a certificate. If you clicked yes, you will get that certificate. And we know that's important for those of you who are getting CEUs. Obviously, you know, if you're getting the CEUs, how the process works for you, that you maintain copies of your certificates in case you are audited. You're able to show those to your auditing body. So for attorneys, we take care of it. If you requested a certificate, you'll get one. If you can see how many participants are on this training, you see that there are a lot of participants on this training. And I think the vast majority of you did request certificates. So please be patient with us. We do create the certificates after the training. It probably will take our team, you know, about a week to get those certificates to you. You'll be receiving them via email to the address that you registered with. So please be patient with us. You will get a certificate, but due to the large volume of attendees that we have, it may take a little bit longer than normal. So let's, oh, wow, Sierra, you are on it, or Latina, you are on it. So we want you to tell us who you are, a little bit about you. I know a lot of people have already introduced themselves in the chat, which is amazing. But please let us know through this poll who's joining us today. Oh, and I should mention that if you are an attorney, another way that we track attendance other than the check-ins is the polls. So please do complete the polls, especially if you're here for CLEs. We are required to, capture attendance and participation in multiple ways by the Supreme Court. And so polls are one thing that we use. Excellent. We have a great mix and we're so excited. So we have a judge, some prosecutors, a lot of community-based and system-based advocates, folks from probation, law enforcement, counsel for victims, counsel for defendants, social workers, counselors, an amazing mix. So everyone here is going to have something to contribute. So like Bree said, please interact with us, ask the questions, chat with each other. Even though this is remote, we hope that there can still be, that interaction that can make training so valuable.
Absolutely. So now we're going to start off talking a little bit about who we are and what we do as an organization. So as you know, our name is Ohio Crime Victim Justice Center, and we were founded back in 2000 by our executive director, Kathy Harper Lee. If you guys do not know her, she is incredible. She has a wonderful, heartbreaking, but amazing story about a survivor who was treated terribly by the judicial system. So she created this organization in hopes that others didn't have to go through what she did. So a little bit about us is, some might know, we used to be called the Justice League, but now we are OCVJC. And we are a nonprofit legal organization that serves the whole state of Ohio. We provide free legal assistance to crime victims when their statutory or constitutional rights have been or are being violated. So this whole training is going to be basically talking about what we do, how we can assist, and when you should refer victims our way. So a few of our services are shown on this slide. First, we're going to talk about direct representation. So what that means is, if a victim's rights are being violated, we have attorneys here for free that can represent the victims, and basically make sure that their rights are being heard, their voices are being heard, and offer a free attorney for them throughout the criminal justice process. Training. So we have trainings, obviously, just like this one, that is 4 hours. But we also do smaller ones as well. So say you are a prosecutor's office, a law enforcement agency. We've also done some to hospitals. We basically do trainings primarily to whatever you need specifically. So we can make those trainings as long or as short as you need. This is a lot of information. So say you just want a training specific to the prosecution state, we can definitely do that. Legal advice and assistance for professionals. So say we have a victim or a prosecutor that just needs some advice on what to do, how to handle this case. Maybe they're confused about, is this a victim's rights violation? We have the attorneys here that are wonderful. They would love to answer their questions for them. And again, everything is free. Referrals. So this is a big majority of what us advocates do. We work primarily with the victims, and we're that first point of contact with them. So when we answer the phones, sometimes people are calling us and they might not really know what they're calling us about or for, but they just need assistance and they need help. So we have a lot of different referrals that we can provide them with, a lot of different agencies that we partner with. So we are always giving those referrals to them, helping them with housing, employment, shelters, whatever they may need, we can definitely offer those referrals. And then our victims' rights toolkit. So this is my favorite thing to talk about because I love it so much. And so basically what this toolkit is it is on our website. So you can go on our website and basically learn what rights you have as a victim. And advocates can go on there, anyone can go on there if they're just interested in what these rights are, what they look like, and whether they're mandated by the court, by law enforcement, or whether you actually have to request them. So that is a really, really key point, because victims might think all of my rights are mandated, but that's not true. There are some of them that need to be requested for them to be upheld. So this toolkit, you can just answer a few questions on there, and then it will auto populate a chart that basically walks through the process with you. So it is awesome. We highly recommend you check it out if you have not. And now we're going to dive into the pre-test. So don't worry, we are not going to show these answers. We will do a post-test at the end, and we will show those answers, because hopefully you will learn a lot. But we'll give you a couple minutes now to answer these questions. All right, awesome. Thank you guys so much for taking the time to answer that. So now we are going to talk a little bit about terminology. So throughout this presentation,
Hey, Bree.
yeah,
I think we usually give people a little bit more time for this because of the number of questions. So I'm just gonna give like another minute, just because
Okay.
I can see that we haven't had everybody come in yet. I want to give everyone a chance.
perfect. That sounds great.
But I understand, Bree, because it is hard to smile for 4 minutes straight. So I get it.
I know it's so awkward. I'm like, okay.
I mean, for you, it's not that hard, but
I know, but it makes your face hurt a little bit, so it's okay.
so we'll wrap up this poll here in about 30 seconds.
All right, so now we're going to go ahead and talk about terminology. So going through the training, we are going to be using victim instead of survivor. And we do not mean to cause any harm by that. But that is a legal definition. So when we go to court and we're talking about the victim, that is basically just a way that the Constitution applies to them. So again, we know that some organizations will use survivor, but here we're going to go ahead and use victim. So on this slide, this is pretty awesome. I know this is added in this presentation in this PowerPoint. So if you've been here before, you probably have not seen this. So we will go ahead and give you guys a second in case you want to take a screenshot or picture of this, because throughout our presentation, we are going to be using, or you will see some of these acronyms on the slides. we'll try to say, you know, law enforcement instead of LE when we're talking, but just in case you see it on a slide and you're not familiar with what it is, here's a little bit of what we're going to be talking about today. So we'll give you a couple seconds there. Oh. And then after that, we're going to go ahead and talk about who is a victim. All right, so now we're going to do this poll and we will give you guys about a minute to go ahead and answer this. And I promise I will actually give you a minute. Okay, so yeah, you guys did great on this. So who is considered a victim? All of the answers are correct on this slide, and this is a little bit of a spoiler for what Elizabeth is going to be talking about here shortly. So I'm not going to dive too much into it, but we will go ahead now and just talk about the definition of a victim. So Marsy's Law and the revised code expand the legal definition of victim to protect the person against whom the criminal offense or delinquent act was committed and or the person directly and proximately harmed by the criminal offense or delinquent act. So Marsy's Law and the revised code expanded this definition tremendously. Now this definition covers a lot more crime victims, so a lot more victims have rights going through the criminal justice system.
Yeah, as Bree said, the definition in the Constitution is a lot broader than we have in the current, but only temporarily current language of 2930-01. And so this is going to be largely, as we go forward, a question for courts in some respects. There are some groups of people that we think it's pretty intuitive that they would qualify as victims. And obviously the vast majority of you agreed with that when I think 96% of you said that parents of child victims are victims in their own right. I think 97% of you said the families of homicide victims are victims in their own right. And I think it was about 72% of you that said witnesses to a mass shooting are victims in their own right. And I think that those intuitions are correct. The mass shooting question is a harder question because someone who witnesses a mass shooting could be a person who is standing right next to someone who is injured. It could also be someone who's across the street, but still within what we think of as the zone of danger. But it could also be someone who's down the street in a high rise who can see what's happening, but none of their family, no one that they know, and they themselves are not within the zone of danger. And so I think that going forward, when we think about how this victim definition can be applied, and I don't want to belabor the point, but this victim definition is critically important because if the people that you're serving meet the victim definition, they get all of these rights that we're going to spend 4 hours talking about. And if they don't meet the definition, then they don't. So really, this is kind of like the fundamental gatekeeper issue of whether this person is a victim. And I think, like I said, this will largely be a question for our courts in those more challenging circumstances where it's someone who witnesses a mass shooting, but they're not within the zone of danger. And so far, we have a couple of decisions that kind of hint around this victim definition and talk about things like foreseeability. In other words, when the defendant committed the criminal offense, was it foreseeable to the defendant that this person would be harmed? So when we talk about a parent of a child victim, I think that I hope at least that we would all agree that we love our children. I love mine. You can see his toys in the background. And so if something happens to him, of course, like that is going to be harmful to me. So I think it's pretty reasonably foreseeable that if you harm a child, the parent is also going to be harmed. Same thing with family members of homicide victims. To me, that's pretty self-evident that if you murder someone's family member, the entire family of people who care about that individual are going to be harmed by that. But there are definitely circumstances where it can be a lot more gray, and it will be ultimately, like I said, up to our courts to provide us some guidance on what that looks like. One thing that's helpful in the new legislation, and so remember today's training, as we kind of hinted at in the beginning, is not just about the constitutional amendment. Now we're transitioning into talking about this new legislation that's been passed, that's going into effect on April 6th. So bear in mind that as we sit here today, these new sections that we share with you are not in effect yet, but we want everybody to get a jump start on what the law is going to be. There's no question that this is going into effect. It's been passed by the House, it's been passed by the Senate, it's been signed by the governor. So this is going to be the world that we all live in when we wake up on April 6th. And one of the things that we had, a lot of conversation about when this legislation was being drafted is how are people in the criminal justice system supposed to know who's directly and proximately harmed? Some of the people are going to be obvious and some of them are not going to be obvious. And so we added this provision, and you have the citation for it there on the right side, that basically says, if I am saying I'm directly and proximately harmed by this criminal offense or delinquent act, I have to affirmatively identify myself and say, hey, I'm Max's, that's my son, I'm Max's mom, so I am a victim by virtue of being directly and proximately harmed. And this kind of takes some of the guesswork out of it for law enforcement and prosecutors and courts, and that we don't have a situation where someone who really should have had notice doesn't have notice because, honestly, through no fault of their own, the criminal justice system officials don't know who to be talking to. In terms of the actual victim definition that exists both in the Constitution and newly in 2930-01 of the revised code, we only have a very limited guidance. And all the Supreme Court has really said at this point is that if you are a governmental entity performing your governmental functions, you are not a victim for purposes of Marsy's law. So that's City of Centerville versus NAB, a case which was about a defendant who was charged with, calling in essentially a false mass shooting. The defendant had, my understanding is that the defendant had some mental health issues and potentially some substance abuse issues and believed that there was a dangerous situation happening, but there actually wasn't. The defendant was charged with I think 2 crimes for calling law enforcement when there wasn't a reason to do so. And the city tried to recover restitution from that defendant, and the Supreme Court said no. So we do have that limitation, but really it's the only limitation that we have. Some of our district courts have also looked at whether an insurance company could potentially be a victim under Marsy's law. And just like they have done before Marsy's law went into effect, they've said, no, we don't think that an insurance company meets this constitutional definition. They have other ways to recover the money that they've lost in the civil arena, but we're not going to worry about them in criminal. But that hasn't even really reached the Supreme Court. So the only guidance that we have from the Supreme Court that covers the entire state is in NAB. So let's talk about, before we really dive into these rights and like the meat of the presentation, a victim's role in the criminal justice process. What does that look like? And this was the same before the Marsy's Law constitutional amendment. It was the same before House Bill 343 and all of these changes that we're getting to victims' rights statutes. It's the same now. So this has been the way that it's been for a very long time in this country. And victims' rights laws don't change the fundamental dynamics of the criminal justice system. So the state of Ohio is a party to the case. They bring the charges for the criminal offense or delinquent acts on behalf of the state. The prosecutor represents the state of Ohio. The prosecutor doesn't represent the victim specifically. They represent the entire state. And then the defendant is an adult who's charged with committing one or more criminal offenses, and an alleged delinquent child is a minor who is accused of committing delinquent acts, which are things that would be crimes if they were committed by an adult. So those are the parties, right? Two, the state and the defendant or the alleged delinquent child. That's it. Who's missing? The victim. The victim is not a party. The victim was not a party before the Marsy's Law Amendment. The victim wasn't a party before this legislation, and after this legislation, the victim is still not a party to the criminal case, and that's very important. The victim is an important stakeholder in the criminal justice process. They have rights. They have the right to have those rights considered, but that doesn't make them a party. And it's really important to understand that, because parties in the criminal justice process have rights and responsibilities beyond that a victim is going to have. So in terms of the criminal justice process, some of you guys can tune me out at this point, because I know a lot of folks on here are very familiar with the criminal justice process. I'm not telling you anything that you don't already know, but I also know that we have some people on this training that are new to the criminal justice process. And so I want to make sure we all have a baseline understanding before I start talking about arraignment. And then you're like, what's arraignment? So baseline, right? Really, really basic, getting down to like the broad strokes of the criminal justice process. You have a crime that is alleged to have been committed, right? And then you have an investigation. Now, as we're going to talk about, some victims are going to start what I like to call their criminal justice journey at the hospital. But every victim is going to experience an investigation. Every case that ultimately moves forward is going to have an investigation, which is conducted by law enforcement. If the investigation leads law enforcement and the prosecutor's office to believe that, potentially a crime has been, or they should believe that they can prove beyond a reasonable doubt, to be honest, that a crime has been committed, then there will either be an indictment in a felony case or a complaint in a misdemeanor case that's going to kick off the process. That's a charging instrument that accuses someone of committing a crime or a delinquent act. And then you're going to have the first appearance of the defendant, the arraignment. The arraignment is really important to everybody, but it's really important to victims as well, because a lot of important decisions are being, I just said important so many times, but a lot of critical decisions are being made at the arraignment that are going to have an impact on the victim. If the defendant is going to be released, what are the terms of that release going to be? Is the victim going to get a protection order? Does the victim want a protection order? Sometimes a victim might be eligible for a protection order and might not be interested in that. So being able to come to arraignment, to know when it is, to have a little bit of time to make arrangements with work and childcare so that the victim can come to the arraignment and let the court know where the victim stands with regards to release, a protection order, and other important decisions that are being made at that point. Super, super critical, and kind of sets the tone for the victim's involvement in the rest of the case. So then in between the first appearance of the defendant and when we ultimately potentially go to trial, but more often resolve the case with a plea deal, you have pre-trials, discovery, and motion practice that are going on. Pre-trials can be anything from a hearing where we're just talking about when's the next pre-trial going to be, and we don't even go on the record, meaning we don't even have a public proceeding, to a change of plea hearing could also be a pre-trial where the defendant says, okay, I'm going to plead guilty to, maybe this lesser offense than the offense that I was charged with, and we're essentially going to resolve this case. At the same time, discovery is going back and forth, and hopefully you're not going to have a change of plea before you have discovery, because you want everyone to know what the state's evidence is, and that's the discovery process, the exchange of information between the state and the defense. Now notice, who's missing? The victim. The victim isn't in this exchange of information. If the victim gives information to the state should probably be turning that information over if it's exculpatory, right? That's Brady versus Maryland, a case that I hope all of us who are in criminal justice land are aware of. But if the victim's information is not within the possession or control or reasonably available to the state, the victim is not a part of that discovery process. There's an independent process where the defendants can get information from third parties, and we'll talk more about that. But for now, it's just important to understand that discovery is the exchange of information between the defense and the state. And then you also have motions. Motions are simply a request to the court. In law school, my professor said, a motion can be anything. You can make up a name for it. As long as you can ask for it with a straight face, you can file a motion. He called it passing the laugh test. So that's true, right? There are some motions that we see over and over and over again in criminal cases, like motions to suppress, motions to dismiss, motions for continuances, of course, are incredibly common. And then there are other motions that can be unique to the circumstances. So some of those motions will implicate victims' rights. We'll kind of talk about that when we get there. And then finally, if the case isn't resolved with a plea deal at one of these pre-trials, then you move to trial. And after trial, especially if a defendant is convicted, you're going to most likely have some form of appellate proceedings. And appellate proceedings can be incredibly complicated. Anything from the direct appeal that follows, the conviction. So I go up to the appropriate court of appeals, potentially to the Supreme Court. But appellate proceedings can also be collateral attacks on the conviction, habeas corpus writs. There's an entire world of collateral attacks and things that happen outside of the direct appellate process. And victims' rights are going to attach in different ways in all of those proceedings. So we'll talk about that in a lot more detail throughout the course of today, but we just wanted to give kind of this broad strokes overview of the criminal justice process. So to recap, the victim, not a party to the criminal case. And some of you guys are like, why have you said 900 times that the victim is not a party? We get it. But maybe you do and maybe you don't, because when we have the post test at the end of this, some of you guys are going to say that a victim is a party. It happens every time. So I was like, I'm going to make its own slide with a really big, bold header on it that says a victim isn't a party. And hopefully no one gets tricked at the end. So a victim is not a party. They're a non-party. They do have specific rights. If you want to think about another non-party that has specific rights, you have the press, right? The press is often involved in criminal cases and sometimes civil cases. They have specific rights to be present for proceedings, sometimes to record, to report on what they're seeing. But that doesn't make them a party to the case either. The whole goal of victims' rights is to give victims a voice, but not a veto. So that's another really key piece to keep in mind as we talk about all of these rights under the Constitution and the revised code, is that the people who are making the decisions in the criminal justice process still remain the same. Victims' rights are just to make sure that the victim's voice is heard in that decision-making process. So judges, law enforcement, prosecutors ultimately make these decisions. They get to decide. Victims' rights are just designed to make sure that victim input is considered in that. So where do the rights come from and when do they apply? They come from all different places and they apply at all different times. That's the long and short of it. It depends. It's the lawyer answer. But we do have constitutional rights. When I say Marsy's law, that's Ohio Constitution, Article 1, Section 10A. That went into effect in 2018. So actually in February of 2018, so 5 years of the Marsy's Law constitutional amendment. We have statutes. Primarily, we're talking about revised code section 2930. That is where a lot of the changes in House Bill 343 are housed. Case law also provides clarification, and we're going to talk about that a lot today, especially when you have constitutional rights that deal with things like safety and privacy and protection. You need the courts to kind of explain and expound upon what that means. There's also administrative regulations, court rules, and Department of Health protocols. We're going to talk about all of these sources of legal rights today. And the rights apply. Oh, did I steal this from you, Bree? I think I did.
It's okay. You were going to, but you didn't yet.
Didn't yet.
So So now we're going to talk a little bit about the phases of the criminal justice process. So a lot of people hear about victims' rights and think that they solely apply to the prosecution stage, but that's not true. Victims have rights throughout each of these stages and phases that you see on the slide right now. So during the hospital, investigation, prosecution, and post-conviction. So we are going to go further into detail about each of these and the rights that victims have throughout. So it should be noted that some rights apply at specific stages of the criminal justice system, while others apply throughout the system. Throughout each phase and right, we will highlight which rights are automatic and which ones must be requested by the victim. So again, if you want some more education on that, go ahead and check out the toolkit because that really dives deeper into that. And now Elizabeth is going to talk more about what exactly are victims' rights before I talk about the neurobiology of trauma.
Yeah, so basically, like Bree said, we have some rights in the Constitution and in the revised code that are applicable throughout the entirety of the criminal justice process. And then we have other rights that come into play at very specific times. And some of the rights that apply throughout the process are the rights that are a little bit more broad. And one of the biggest ones is this right to be treated with fairness and respect for the victim's safety, dignity, and privacy. So that's actually the first in the list of constitutional rights in Marsy's law is this right. And you may say to yourself, well, what does that mean? And I think the answer is we don't really know what it means because it can mean so many different things depending on the context. But absolutely, this right is something that applies throughout the process. And to me, it just means that, at the baseline, when criminal justice system officials are making decisions, they should keep in mind the victim's safety, the victim's dignity, and the victim's privacy. And Bree is going to dig a little bit more into what that really means for us.
Yep. So before I go ahead and do that, we're going to take another poll and then I will go ahead and talk about that. Okay, so for this answer, when we experience traumatic events like crime victimization, we remember the answer is less than we usually would. So 86% of people got that right. And now we're going to talk a little bit more about what exactly that means and why that is the way it is. So on this slide, you have a recording by Dr. Rebecca Campbell. A baseline for respecting crime victims is understanding the neurobiology of trauma. The link here is of a presentation by Dr. Rebecca Campbell. We highly recommend that you all check out this video because it is essential in understanding the process that crime victims go through and how they relate to the criminal justice system. I am sure many of you have heard the phrase fight, flight, and freeze, but there is also one other survival response used by victims, fawn. Fawn means to please, appease, or pacify the threat. Until just recently, these differences were used to discredit victims. What is important to note here is that these varied responses cannot be predetermined and should not be used to discredit victim stories. When someone goes through a traumatic event, that trauma can affect their memory. It can affect how people express their trauma and how victims relate to the world around them. One example of this is after an officer-involved shooting. Officers are given 2 sleep cycles before making a report of what happened. This is the direct result of understanding the neurobiology of trauma. If you compare memory to a Post-it note, going through a traumatic event is like writing what happened down on all different types of Post-it notes and then throwing them up in the air. The memories are not neatly organized, but instead scattered all over the place. Because of this, police officers are allowed 2 sleep cycles so that their brain can organize the traumatic event. Victims are unfortunately not given this amount of time before retelling their story. So it is important to keep in mind that if a victim cannot put the story in chronological order, that is actually normal and simply the result of trauma. Having to retell the worst experience most people have gone through, being triggered, being victim blamed, being looked down on, all of these aspects intensify the amount of trauma a victim goes through. A victim telling you their story is not something that is easy for them. It is very difficult, and it is important that we remember that.
So when we think about this from a legal standpoint, right, like I'll come back in now and talk about the boring legal stuff. But I just wanted to say thank you, Bree, for that, because I think that that's really critical to understanding. And actually, before I talk about the boring legal stuff, I would just say that, you know, when I first started this work, and it's been 10 years at this point, I did not understand anything about the neurobiology of trauma. It's certainly not something that they teach you about in law school. And it is critically important for any role in which you're working with crime victims. And I would say this about the reality of victimization, because I know we have defense counsel on here as well. A lot of criminal defendants have also been crime victims, and a lot of the things that we say about the neurobiology of trauma is going to apply to them too. So really, everyone who is on this training is probably here because you're interacting with crime victims. It's critically important information. And I would absolutely encourage people to get additional training on that. I think that's some of our favorite training in this office. Okay, now I'll talk about the boring legal stuff. So when we talk about this concept of dignity and safety, this is something that, you know, has actually existed in the Ohio Constitution, believe it or not, since 1994. And only recently are we starting to see some decisions from our courts about what treating victims with dignity, with fairness and respect for their dignity and safety looks like. And so in this particular case, which comes out of the 10th district, we had a defendant who attacked a victim, bit her thumb. It was a defendant who was unknown to the victim. She didn't know whether this individual had any type of blood-borne illnesses that could have been communicated to her through the bite. And so she was simply asking for exhaustive blood testing of this defendant. And basically, the trial court was refusing that request. And at the 10th district, we had some nice language where they said, ultimately, the decision was that the trial court hadn't properly analyzed the constitutional argument for the victim, so the case got sent back. But the 10th district did say very clearly that we absolutely think that a victim's, you know, dignity and safety are implicated in a trial court decision that denies a victim's request for blood testing. So it's maybe not the first thing that you would think about when you think about dignity and safety, but this is just one example of how these new constitutional provisions and the provisions in the revised code give us the ability to be a little bit creative in ensuring that we're meeting our clients' needs. When we talk about privacy, and this is my least favorite decision to talk about because I wholeheartedly disagree with it, and we do have a silver lining, so stay tuned. But essentially, in this case, the Ohio Supreme Court took up the question of whether or not releasing, well, basically what the scenario here was, like I get tongue-tied about it because it's so infuriating, but we had a minor victim. The defendant had pled guilty to, I think, 7 counts of sexual battery for the sex crimes that he committed against this victim. So he pled guilty. he was sentenced. He was serving time in prison. And at that point in time, his parents decided to start doing public records requests for all of the information that was related to the criminal case. And when the prosecutor's office tried to exempt victim information from that, the family challenged this in the Ohio Supreme Court and said that they were entitled to this. And we knew what they were doing with the victim information because they had already gotten some from another jurisdiction. And they were posting on Facebook the victim's image, her name, her address, her contact information, both, still images and videos of the victim, very graphic descriptions of the sex crimes committed against the victim. And they were doing all of this really for no other reason than to bully the victim. And they were encouraging people to reach out to the victim and tell her that she's a liar. It was really atrocious. And so we became involved on behalf of the victim. And we said, no, these should not be a part of the public record. Victim information should be, redacted prior to release of these records. And the Ohio Supreme Court disagreed with us. And they said that this Marsy's Law right to privacy doesn't guarantee that victims have the right to privacy in public records. And luckily, we were able to address that with a new provision that's going into effect in April 6th, 293007. And basically in this provision, victims have the right to request redaction of their names, contact information, and identifying information from public record. So if the victim makes this request, the information has to be redacted. And we're going to talk a little bit more about what that request looks like and mechanically what happens in upcoming slides. But I couldn't leave that case hanging. I'm so happy about this provision. This is one of my favorite provisions in the new legislation, in the new law, because I think that protecting victim privacy is so, so critical. If victims think that their privacy is going to be sacrificed to participate in criminal justice, a lot of victims just aren't going to come forward. So to me, protecting privacy is one of the most critical things that we do.
Elizabeth, I think this one is you too. I think I'm going the next one.
You're right. It does say 35. Thanks.
It's okay.
So we also have, remember the overall topic here is rights that apply throughout the process. And we also have this right to reasonable protection from the accused and anyone acting on behalf of the accused. And that can look like a lot of different things as well. Again, it's clear that it applies throughout the entirety of the criminal justice process, but this also gives you license to be creative. So we will give you an example of what this looked like for one of our clients, but that doesn't mean that that's the only option. Oh, hey, Sierra.
Hello. So we do have a few questions. The first one is, do victims have the right to request blood testing if something like that is involved, or do the case law state no?
So basically, we did not get a clear decision on that issue from the 10th district. That's a great question. They basically said that the victim did have the ability to make that request, but because the trial court did not analyze the constitutional issue in its decision, the case got sent back to the trial court. So I guess what I would say is the 10th district language to me makes it pretty clear that a victim can make that request, that would potentially be contemplated within this concept of dignity and safety. But we don't have a decision that explicitly says that. So if you have a case where you want to try it, we will try it, because I think that it does fit. It's just that the trial, we had just a kind of a technical issue where the trial court didn't properly analyze the Constitution. And so we ended up with the case being sent back.
Okay, another question. Will it change the way law enforcement writes complaints for the court system? Currently, we put the name of the adult victims in complaints, but only initials and date of birth of juvenile victims. Or will the redaction be done by the court and for any public records released from law enforcement agencies?
Yeah, so that's a great question. We're going to get into a lot more detail with that, so I don't want to jump too far ahead. But essentially, when we talk about redaction, criminal justice system officials will still have access to unredacted records for their own use. So this is not saying that when law enforcement generates records, they should call every victim Jane Doe or John Doe going forward. This is just that prior to those records being publicly released, that information has to be blacked out. You know, redaction software is pretty commonly used by law enforcement agencies, and that's really what we're looking at, not a blanket prohibition on creating any records that have victim information.
All right, and our last question, does this include a person with a confidential address?
So if we're talking about the Secretary of State's safe at home address, that information obviously is designed to be shared in legal documents. But the redaction right applies to everybody. So if for whatever reason the victim didn't want that information to be publicly released, that would be their prerogative. It's any victim name, contact information, and identifying information. And the identifying information piece is really important, because if we call a victim Jane Doe, but then we have public records that say Jane Doe's father did X, Y, and Z, well, now everyone knows who Jane Doe is. So the language contemplates identifying information as well, and that's really critical.
Thank you.
Thanks, Sierra. So I think our last case law spotlight for a little bit deals with the rights to safety and reasonable protection, these rights that apply kind of throughout the criminal justice process. And in this case, beyond the criminal justice process, because actually this case was about a defendant who had been convicted by a jury, incidentally, of domestic violence. And if you're not aware, and you may not be, this is kind of a little known fact, but if you are convicted of misdemeanor domestic violence or an offense that includes harm to a family or household member, so it doesn't necessarily have to be a domestic violence conviction, that's an important side note, you have a federal firearms disqualification, or sometimes called disability. So that means that if you've been convicted of misdemeanor domestic violence, by function of federal law, you're not allowed to have firearms. So that's important, because this defendant, as soon as his probation ended, he went to the Court of Common Pleas in the jurisdiction where he had been convicted of the misdemeanor, and he filed an application for relief from his federal firearms disability. And he is basically asking the state court judge to relieve a federal disability. And we were contacted by a colleague at Ohio Domestic Violence Network who was working with this victim. And she said, you know, is there anything that we can do for this victim? You know, the trial court has now granted this request and has told this defendant that he is able to have guns again. And so we decided to file on her behalf something called an extraordinary writ of prohibition. And that's basically an action that is captioned State of Ohio XREL victim versus judge, which is a little uncomfortable. And it's basically a claim on the part of the victim that the judge didn't have the judicial power, didn't have the ability to relieve this federal firearms disability. And we brought this action under Marsy's law. Under the Constitution, basically saying that by giving this man who had been convicted of domestic violence his firearms back, the court was endangering the victim's safety and violating her right to reasonable protection. And so we filed this case originally in the 12th District Court of Appeals, and we won in the 12th District Court of Appeals. And the case was appealed to the Supreme Court, and the Supreme Court heard the case, and the victim won in the Supreme Court as well. And the Supreme Court said that it was an appropriate application of this victim's rights to safety and reasonable protection for her to bring this action objecting to what this trial court judge had done. And so the Supreme Court said, no, a trial court judge cannot relieve a federal firearms disability. The judge does not have the power to do that. So that is a really good decision. One of the first, I think maybe the first of its kind in the country to apply victims' rights in that way. And I just give a shout out to an absolutely amazing client who really stuck it out through a very, very long litigation process for a case like this to try to establish this right, not just for herself, but for other victims like her throughout the state and the country. So long and short of it, these rights that apply throughout the process, you can be creative with them. And honestly, you can even take them sometimes outside of the criminal justice process, which is what we did here.
So I do see a couple more questions, Elizabeth, before we dive into this slide. So we have from Casey, it says, do you think there is a potential that the recent ruling in Texas will trickle up to Ohio?
Casey, I'll be honest with you, I don't know what the recent ruling in Texas is. So if you want to say more about that, I would be happy to share my probably wrong opinion on that.
All right. And then the other one is, how is this impacted by recent federal appeals ruling that a probation officer doesn't require gun disability for domestic violence offenders? Am I right about that?
Okay, so when we talk about federal firearms disabilities, there are two separate disabilities. Well, there are actually more than two, to be fair. But this question implicates two of them. So I'm going to blow your minds right now because I'm going to throw out a federal statute and hope that it's right. So 18 USC 922 G8 deals with the protection order piece of it, where if you have an active protection order against you, you have a gun disability, a firearms disability at the federal level. The firearms disability that is created when you have a misdemeanor domestic violence conviction is separate. That's 1822, 18 USC 922 G9. So any holdings or any decisions that implicate the protection order piece of it do not have an impact on the misdemeanor conviction piece of it. They're two separate federal firearms disabilities, one dealing with protection orders only, one dealing with misdemeanor domestic violence convictions.
You are seriously unreal that you just spew all of that out like that. Hi, Sierra. Is there another question?
Yeah, I didn't know if you saw it in the Q&A, so I just wanted
I didn't. Go ahead. Thank you.
So what about expunged records? Currently, if we have someone who was convicted of a crime which prohibits the possession of firearms and the records are expunged, we cannot deny a concealed handgun license.
Yeah, so now we're talking about two separate things here too, because firearms disabilities and the ability to get concealed carry, which I don't even know why people are doing that now, because now we have this law in Ohio, no matter how you feel about it, that says that you can have a gun, you don't have to have a concealed carry permit. But in any case, those are two separate things. There is a completely separate statutory scheme for who can get a concealed carry permit versus who can have a weapon. But in terms of the larger question here, domestic violence is not an expungable or sealable offense. So for our particular purposes in that case, this federal firearms disability, in Ohio, the law is very clear. And we recently passed Senate Bill 288, which has a lot of criminal justice reforms. But the expungement piece of that does not change the fact that you cannot expunge domestic violence. So we have a separate disability statute in Ohio, a state disability for felons. It's called weapons under disability. If you've been convicted of felonies, you can have that disability removed. That is something that state court judges can do. And then you can also have a lot of, felonies can be expunged as well. And in fact, even more felonies can be expunged under the new scheme under 288. But that doesn't affect domestic violence. So domestic violence at the end of the day is kind of set apart from other felonies. For the most part, though, violent offenses of violence, I should say, because that has a legal definition, are typically not expungible.
Okay, so we have another question. I worked with a client whose batterer was served with a CPO in jail. He was released on bond and no one would take his guns. I called everywhere. What can I do? He's facing a felony charge of assault with a deadly weapon.
Yeah, that's a great question. And if anyone here has the answer to it, I would love to hear that because we bump into that issue all the time. I think the reality is that, there's still this hesitation due to especially, decisions in, I say recent years, but like the last decade or so relating to the Second Amendment, where there's a real hesitation to go into someone's home and take firearms. So, we check the box on the CPO paperwork that says you're not allowed to have firearms, but it is very hit or miss throughout the state as to whether law enforcement will actually facilitate the removal of firearms. And in fact, in the case that I was just discussing, we had this exact issue where we knew that this defendant may very well believe that he was able to have firearms now. And myself and Michaela Deming, who was at ODVN at the time, we spent a ton of time on the phone calling state law enforcement agencies, federal law enforcement agencies, federal prosecutors. And we were saying like, hey, we think that this individual has guns. We think he might think that he's allowed to have guns, but we think he's not allowed to have guns. Is there anything that can be done? And, kind of, to be honest, the response that we got was, unless we catch him with a gun and he's doing something else, nothing is really going to happen. And that kind of is proven out, unfortunately, in the case law too. When you actually dig into the federal weapons under disability case law, it's always like Jimmy was out hunting and he killed a pheasant out of season. And then we realized, oh, not only wasn't he allowed to kill that pheasant, but he also isn't even allowed to have a gun. And now he started off as an issue with the Department of Wildlife, and he's now going to have an issue with federal prosecutors. So that's basically to say it's an incredible challenge. And if anyone has any suggestions that they want to share in the chat for how you've successfully workshopped that, we would love to hear them because it is a challenge for us as well.
Awesome. Thank you guys so much for all the questions, and thanks Elizabeth for handling that. So now we're going to talk a little bit about the right to effective communication. So victims with disabilities, non-English speaking, and or limited English proficient victims have the right to a qualified or certified interpreter at all meetings with the prosecutor, contacts with law enforcement, so that includes interviews with law enforcement, court proceedings, in contacts with probation, the Department of Rehabilitation and Correction, and or the Department of Youth Services. So this one is awesome because we have had cases in the past where we've encountered this issue. Also important to note here that all of these services are paid for by the court. So victims do not have to pay for an interpreter for themselves, and hopefully this will help kind of eliminate some of those issues that we've seen in the past. So on the next slide, we're going to talk a little bit about public records related to a victim's case. They are available to the victim at no cost. So this is also a really huge important fact, because in the past we've had victims that have had to pay for their transcripts, for their court records sometimes, and those can be costly. And as a victim, they should not have to pay for their own records. So this is also a really important new fact that is in place now because of the passage of House Bill 343.
Just a point of clarification here, transcripts are separate from public records. Victims may still incur costs for transcripts. We do have a later provision that says victims should get a dramatically reduced cost for transcripts if someone else has already ordered the transcript, which is common during an appeal. But just for a point of clarification, transcripts are a little bit different, but everything else is considered a public record. Law enforcement records, filings that are made with the court, anything that, is listed on the docket, essentially, aside from a transcript, would all be at no cost.
Awesome. Thank you. And now we're going to talk a little bit about victims' rights at the hospital. So again, this is specifically the hospital stage.
So when we think about the hospital stage, we come back to this right that applies throughout the process, this right for all victims to be treated with fairness and respect for their safety, dignity, and privacy. And, so I think sometimes the folks who work at the hospital think, oh, I'm a part of the medical system. What's happening in the criminal justice system doesn't necessarily apply to me. But the reality is, for some of the victims that Bree's going to talk about here in just a moment, they are starting the criminal justice process in the hospital. And the purpose of their visit, especially for victims of sexual assault, may be the collection of evidence for criminal justice ends. So once that machinery is engaged, these rights apply. And so it is critically important to keep that in mind, that this is kind of a dual process. This is a medical process, but this is also a part of the criminal justice process. And so, as I was kind of referencing, there are only going to be certain victims who are going to engage with the hospital process, victims of sex crimes, domestic violence, and felony level assaults. But for those victims, that is the beginning of the process for them.
All right, so now we're going to talk about sexual assault at the hospital stage. So first, we're going to talk a little bit about interpreters. It is a protocol requirement for hospitals to provide interpreters for victims of sexual assault. This is really key. If someone is unable to effectively communicate with a victim at the hospital stage, that is going to create a lot of issues for the victim on a personal level, which is terrible in itself, but also issues with the case as it moves through the criminal justice system. And Elizabeth, I know you always share this story, so please correct me if I say it wrong at all, but she actually had a client that was not English speaking who responded to the hospital, but the hospital did not have any Spanish speaking individuals to provide interpretation for this victim. So the hospital called in a nearby university student to provide this interpretation. Well, the student simply did not have enough training and education to be able to translate the difficult medical and legal terms. The result of this was that the statement from the victim didn't make any sense. It was clear by the translation that the victim had no idea what was going on and the questions that were being asked of her. One of the questions specifically was supposed to ask what was if the assault happened after 96 years. Well, the student translator asked if it happened after 96. Oh, wait, sorry, going back with that one. Asked if the assault happened after 96 hours. So that was what she was actually supposed to be asking. But the student translator asked if it happened after 96 years. So of course the victim stated no, that it did not happen after 96 years. And this is a great example of how just getting a few words wrong can create a very problematic statement for the victim, and it can affect the entire rest of their case. How did I do, Elizabeth? Is that correct? Perfect. That one's hard. That one's like a tongue twister. Okay, so now we're going to take a poll about which hospitals have to provide safe kit collection and safe exams to the victims. Okay, so this one, there are a lot of different answers. So for the answer for this one is actually only hospitals that offer emergency services. And we're going to talk a little bit more about what all that entails. So the revised code states that if the hospital provides emergency services, then the hospital must have someone on call 24/7 to provide a sexual assault forensic exam. So the answer is only hospitals that provide those emergency services. This is not just a protocol, but a written statutory law. The other thing we like to discuss here is who should actually perform this exam. We also love to give a huge shout out to all the SANE nurses, which stand for Sexual Assault Nurse Examiners. SANE nurses are specifically trained RNs who have had significant trainings about working with victims of crime. The hospital stage is one of the initial interactions a victim has with reporting and the criminal justice system. This interaction will determine how the victim feels about the process moving forward. So for us, the preference is to have a SANE nurse perform this exam. Now we're going to talk a little bit about the timing. So there are different timeframes listed on this slide based on the prime times to collect DNA evidence for a sexual assault. What BCI and other evidence labs around the country have found is that if you're dealing with a victim 15 years and younger, the prime time to collect DNA from that person's body is within 72 hours of the assault. With someone that is 17 years or 16 years or older, the prime time to collect DNA would be within 96 hours of the assault. So why is this shorter for victims of minor victims and children than it is for adults? One reason is that children tend to be much more active than us adults are. We are probably sitting at desks 8 hours a day like we are, or, working a job where you're not constantly running around, playing, riding bikes, climbing trees. Young children also may not be able to control when they bathe, when they go to the bathroom, when they brush their teeth. So for that reason, it is simply more difficult to collect the DNA evidence from their bodies. It is also important to note here that just because a victim is outside of these timeframes, a hospital can still do an exam and look for any injuries. So a victim can always go in and have an exam performed. They may not be able to do a kit involving the DNA swabs, but they can check for STDs and outside injuries as well. So now we're going to talk a little bit about anonymous kits. There are some victims who know they may want to collect and preserve the DNA evidence, but they are still not sure if they want to report the assault to law enforcement yet. This happens quite a bit, and it's very understandable. So the Ohio Department of Health protocols allow for that. So essentially, only the hospital will know that the kit belongs to a specific victim. The hospital will still do the kit, send the evidence to the law enforcement agency, and law enforcement will still have the kit tested for any DNA hits at that point. However, the kit will only be associated with random numbers instead of the actual victim's name. If there is a hit in the system, the hospital will then call the victim and inform them that there is a hit, and the victim has a choice at that point what they decide to do. This provides victims flexibility, power, and control, and allows them to make the right choices for themselves. Minors can also consent to the collection of a kit without authorization from a parent, which makes sense when you really think about it, because statistics have shown that minor victims are often being abused by a member of their household. So if they get a trusted adult to bring them to the hospital, the minor child can consent to the collection of a kit by themselves. Many hospitals do have policies, though, that if a minor comes in for a kit, the parents of the child are notified after the fact. So it is extremely important that law enforcement and hospital personnel build a strong relationship with the victim so that they are fully informed to not put the child in any danger at home with their abuser. Finally, parents cannot force minors to submit to a kit on their own. Hospitals will require victims to still consent. Next, we're going to talk about drug-facilitated assaults. So victims of sexual assaults can also request and receive testing if they suspect the assault was drug facilitated. So it's also called DFSA. And this kit will not automatically be collected and tested in some jurisdictions. So we really like to point this out because victims, they might think that it's automatically going to be collected. So if a victim believes that they were drugged at all, they must ask for a drug facilitated sexual assault kit to be collected at that point. Okay, so financial costs. On this slide, you see a little bit about what victims of sexual assault cannot be charged for and what they may be charged for. So some of the things that they cannot be charged for are the collection of evidence via a safe kit, administration of STI antibiotics if part of the exam, and then a 28-day cycle of HIV PEP. And then also important to keep in mind that victims may be charged for some medications, emergency room fees, treatment for injuries, emergency contraception, and toxicology or drug testing. So again, just important to keep this stuff in mind going forward. So victim compensation. I also love talking about this because I just think it's a great program. So victim compensation is through the Attorney General's office, and it is basically a reimbursement program for victims of violent crimes who have had to basically pay for things out of pocket. So anything that they may have had to pay out of pocket for, we suggest them at a very early state to start collecting those receipts and those bills, because you are going to have to, as a victim, actually fill out an application through the Attorney General's website and then actually attach those receipts and the bills so that you can basically prove your losses. There are some new guidelines for what the Attorney General's office actually compensates for. So we definitely suggest taking a look at their website. Thank you, Sierra, for putting that in there, and just seeing what some of those new guidelines are, because that changed, I believe, back in March. So it's been about a year since those new guidelines have been in place. So some practice pointers, they should be encouraged to apply for compensation if eligible early on. Again, and some of the things that they compensate for are counseling, mileage to and from court sometimes, parking at court, medical bills. So if they go to the hospital and they have medical bills, victims can actually get those bills directly. A lot of times they get them sent directly to their house, and they can actually send those bills directly in with their application. So compensation, victims of crime will actually pay for those bills directly so that victims don't have to pay for them immediately. And then also important that victims cannot double dip. So say, for instance, they end up getting restitution from their criminal case. So a defendant was convicted and they get awarded restitution. If that defendant starts actually paying the restitution back, and say the victim already got awarded compensation, you can't get both of them. So if they get some of that restitution, they're actually going to have to send it back to the Attorney General's office. So if victims have questions about that, they can always reach out to us and we can explain that further, but just something to keep in mind there.
So now
right.
we're gonna talk about how truly investigation can cross over into medical treatment at the hospital and what that can look like. So when we look at the Department of Health protocols, which is what we've been talking about pretty much this whole time with a couple of revised code sections sprinkled in there, the protocols really control how victims should be treated at the hospital. And one of the key points that's raised is that reporting the crime to law enforcement cannot be made a prerequisite to the victim receiving the treatment or having evidence collected. So even though this has been the case for a really long time, we still, here and there continue to have problems throughout the state where victims are told by medical personnel that, this is a sexual assault. If you're not willing to talk to Officer Friendly, then we are not going to proceed with any type of evidence collection or provide you with any type of treatment. According to the protocols, that is strictly not allowed. So victims should have the choice as to whether and what extent they want to participate in the criminal justice process, especially so early on when they're experiencing that trauma that Bree, beautifully described earlier. They may not be in a place to be making these types of decisions, but they may know that they want to have options later on, and that's why they come. We have all these other rights that Bree shared, like the ability to do an unnamed kit. All of those rights are kind of obliterated if you then are forced to talk to law enforcement when you're not ready to do that. So this is really, really critical. But on the flip side of that coin, hospitals are mandated reporters of child abuse. So if we're talking about a child, there's just going to be this hard and fast rule that the hospital is going to have no choice but to report that child abuse to law enforcement or child protective services. And the same thing applies actually to any kind of felony level assault. So rape would be included in that, as well as things like gunshot wounds and other things that would be at a felony level. Those also trigger a mandated reporting aspect for hospitals. Doctor-patient privilege is then another interesting layer to add on to that, because we have this privilege in the Ohio Revised Code where things that I talk to my doctor about cannot be disclosed in court. And that includes my medical records, these records that are generated from my visit. So how privilege plays into this equation is really determined by who your treatment provider is. And of course, you're probably likely to have multiple treatment providers. And to some of them, the privilege may apply, and to others, it may not. So if this is something that you have a question about, absolutely reach out to us, because it can be difficult to analyze who has which obligations in which scenarios. But we want you to know that all of this exists and is kind of interplaying with other pieces of the law there. When law enforcement responds to the hospital, as they often do, those officers really should be crisis intervention trained, if at all available. And this is really, really critical, because when you talk to officers who have actually received the crisis intervention training, they all will tell you that it changed the way that they do police work, especially relative to victims, that it gave them a greater understanding that the initial training that they went through simply did not give them in terms of working with victims. And a lot of that goes back to what all of these protocols and statutes and constitutional provisions are designed to do, which is to give power and control over their lives back to the victim. And so doing police work in that way, especially for someone who is in the immediate aftermath of trauma, is really, really critical. And so we really encourage that any law enforcement who's responding to the hospital be crisis intervention trained. So, oh, hey, Sierra.
I'm back again. We did have a question. I believe we kind of touched on this earlier, but is there any way that we could go back and speak on if minors can submit an anonymous safe kit?
Yeah, so that is a great question. We kind of danced around that a little bit, but ultimately you have to be over the age of 18 to do an unnamed kit. And actually that's the language that we use now. Unnamed as opposed to anonymous is what the protocols discuss. And the reason for that is because of the mandated reporting of child abuse, right? So if you're under the age of 18, the law says that basically any professional that you interact with has to report child abuse. And so the anonymous kit isn't available for that reason. Unnamed. Now I said anonymous. Oh, you tricked me, Sierra.
I'm sorry. I like to confuse you every now and again. We have another question. So if an adult victim of rape goes to the ER and gets a safe exam, is the hospital required to report that even if the victim does not want it?
Yeah, so here's a fun fact that you may not know about the Ohio Revised Code, and that's that every Ohio citizen is actually, believe it or not, a mandated reporter of felonies that occurred. Right. So how many of us are really doing that? No one. No one is really complying with that law. But hospitals do tend to take that more seriously than your garden variety human just walking down the street. So a way that I have heard hospitals kind of comply with their reporting obligations while also protecting the privacy of the victim is to wait until the exam and the evidence collection are over and to tell law enforcement, hey, I had someone in here, they did an unnamed kit. I can tell you that this is where the crime occurred. This is a description of the offender or who we think the offender might be. But at this point in time, the victim doesn't feel comfortable being named. So the law doesn't mandate that you give a victim name. It just says that you report the crime. So you can kind of walk that fine line to protect victim privacy while also complying with your obligations under the Ohio Revised Code. And in the time that we were talking, everyone else was taking the poll, it seems. So I know that I was talking, some of you may have been listening to that. So I'm going to give just a little bit more time on the poll that deals with when victims of sex crimes can be polygraphed. All right. So the results are in, and 3% said a victim can be polygraphed at any time for any reason. That's scary. 19% said for the purposes of beginning or continuing an investigation, and 79% said none of these. The 79% has it. And this is not the protocols, by the way. This is the Ohio Revised Code that tells us that law enforcement, prosecutors, and other officials can't request or require a victim of a sex crime to undergo a polygraph as a condition of either starting an investigation or prosecution or continuing an investigation or prosecution. So sometimes what we see is more of a conversation like, I can't force you to take a polygraph, but I will tell you that if you don't take a polygraph, I just don't know how the case will ever move forward. That is requesting it for the purposes of continuing an investigation, and that is problematic. So this is something that we definitely looked at in House Bill 343. And we did add some language to strengthen this because it has been a problem throughout our state that victims have been either asked or I think of like voluntold almost, right? That's what we call it here, where it's like I tell Bree to do something, or I say, hey, Bree, do you want to do this? And she knows that she has no choice type thing. So that's kind of what this has looked like in our state for polygraphs and victims. And it's been really problematic. So we wanted to make sure to address that.
Awesome. So now we're going to talk about domestic violence. So just like sexual assault, victims do have specific rights throughout this hospital state if they're experiencing domestic violence. So on this slide, this means that if a domestic violence is suspected, victims should be interviewed, examined, and provided resources away from the suspected abuser. Hospitals should also be treating these victims as priority patients. And then here, when it comes to medical records, we definitely suggest that healthcare personnel document exactly what they suspect. So one of our old attorneys that worked here actually had a case where a victim was seen at a hospital and her story did not align with the injuries that she was being seen for. The nurse on shift that day noted in her medical records that she suspected it was domestic violence related, and these notes ended up being the reason that charges were brought against her abuser later on in the criminal case. So now we're going to dive into the investigation portion of it. And just so you guys all know, a couple of things. So this, I feel like from this point on, we are touching on a lot of the new information. So it is very heavy. There's a lot of information on the slides. We'll try and make it as interesting as possible, but also keep in mind that we are going to try and take a break at 10:15. So you'll get about a 15-minute break and then we'll come back in and bore you guys some more. But okay, so this form I think is going to be life-changing for victims, and I am so honored to be able to talk about it, honestly, because one thing that we see a lot here at our job is victims reaching out to us stating that they had no idea what their rights were. They never were informed of their rights, and they just had no idea that they needed to request them or that they were mandated. So this form in itself should eliminate those issues, and we are so excited about it. So this form is the Victims' Rights Request Form. Basically, at first contact with law enforcement, so immediately, victims will and must receive this Victims' Rights Request Form that contains everything you see on the slide. So list of rights that are automatic. So stating right then and there what rights are automatic for the victims. Ability to request other rights if they have to request those rights. Statement that victims can change their mind throughout the process. So that's going to be really important for victims too, because when they're in crisis mode, an incident just happened to them. It's very, very traumatic. They might not know what they want to do months down the road. So that's important too. And then we love this part. Space for law enforcement to indicate that the victim was unable to request the rights. Also, if it's blank, or if for whatever reason a victim does not fill out that space and check, it is automatically, they're opted in to those rights. So and Elizabeth, you please chime in at any point if you want to add, or if I'm saying anything incorrectly, because obviously this is all new to us too.
Yeah, so basically, and by the way, like I have seen this form, if you look at the legislation, House Bill 343, it requires the Supreme Court to create this form. And I'm not going to name any names, but the person working at the Supreme Court is a fabulous, amazing, wonderful, wonderful human. And I've seen the draft of this, and it's beautiful. It's really so much more than we even imagined it would be in terms of the information that it provides, and how clear it is and easy to understand. But basically, I think the key point for this slide is definitely what you were touching on there, Bree, which is that if the victim isn't able to request their rights, then they're automatically opted in. So if you have a victim who let's think about it from a really basic level, they're not able to request their rights because they're unconscious, right? Like they literally physically cannot fill out a form. Then we're going to presume that they want their rights. We're not going to take rights away from them because they're not in a place to make an affirmative request. And the rights that we're going to give them at that moment are key rights, like the right to redaction that we talked about. We're going to presume that they want their name and identifying information redacted before any public release of any type of case documents that law enforcement may have. We're going to presume that they want notifications of proceedings, because when we get to the prosecution phase, we'll talk about that, but that has been and continues to be the most critical right that you do have to request. So we're going to presume that they want to confer with the prosecutor about the case. We're going to presume that they want all of these rights. And it's not just for the victim who's unconscious, right? It's for the person who is experiencing so much trauma that they can't make that decision. And frankly, it's for the person who is a part of a community that has had a traditionally problematic relationship with law enforcement, and they don't feel comfortable filling out that form right now. Right? I mean, it's for all of these victims that they're going to be automatically opted in to ensure that we're not taking rights away from them. Hi, Sierra.
Hello. We have a question. Do you have any sense when OSC will have the form ready?
Obviously they'll have to have it by April 6th. But I think it's in a pretty good spot right now, to be honest. I think that there will be an earlier release than that. I can't make any promises on behalf of the Supreme Court, but I have seen it and it is beautiful, and I had very minor notes. So hopefully we'll see that, well in advance of April 6th. Sorry, Bree, I'm gonna let you get back to it. As you can tell, we all get really jacked up about this.
I know. No, and you are perfectly fine. Please come in at any point, because I just want to make sure we're really getting it all accurate. So also on this form, it's going to say the notice that the failure to request rights may be a waiver of some rights. Space to designate a representative. This is also awesome because they can say, I want my mom to be my representative very, very early on, or an advocate, a best friend, whoever they may want to either be a representative beside them or with them along the process. So that's really awesome. Space to select victim type, whether it's directly or approximately harmed. We kind of think victims are probably going to mark both of those, not really understanding the difference, and that's okay. A checkbox indicating whether the form was provided by the law enforcement officer or the prosecutor. We also love that, because that basically is letting us know the victim did receive this form, and law enforcement or the prosecutors are stating that they gave it to the victim. So huge. Space for address, phone number, and email of the victim and the victim representative. And then contact information of the law enforcement agency, incident number, and the arraignment information if they know this information, which they should know that information. So yeah, that's awesome. Hi, Sierra.
We have another question. Are there consequences if the officers do not give victims the oh my gosh, these words, VRR form?
There are always consequences in life, right? It's just a system of chutes and ladders. No, I'm just kidding. There really are consequences. Just looking, well, and we'll talk more about, how this works in terms of enforcement when we get more into prosecution and we start talking about appellate procedures and things like that. I think it's a little bit different when you talk about failure to afford rights at the law enforcement phase versus failure to afford rights at the prosecution phase, where in the prosecution phase, you're going to see a lot more things that are dealt with by appeal. In the law enforcement phase, you're probably going to see things dealt with using a process that we call, well, we don't call it this, it's called this, extraordinary writs. So when I was talking about the safety and protection case that we had in the Ohio Supreme Court, I said that we used a writ of prohibition. There are other extraordinary writs. So prohibition is one, it's not applicable here, but there is a writ of mandamus, which is what I foresee we would use if law enforcement is not handing out the form. A mandamus writ is essentially a command from a court telling some, in this case, criminal justice system official to do what they're supposed to be doing, to do your job. So it doesn't control how they do it, but it controls essentially, an order saying you must discharge your duties, essentially. So I think that that's what that would look like. And if it sounds really confusing and tricky, it is, which is why if it gets to that point, victim probably is not going to want to take that on pro se or, representing themselves. Instead, they're probably going to want an attorney to assist them with that. But we all know that this isn't going to be a problem because law enforcement is going to hand out this form and everything is going to work fantastically.
I love the optimism.
Well, we do have some more questions. Where is the best place to look for the form release or update?
So the Supreme Court has been tasked, I'm sure much to their joy, with creating this form. So I'm sure that when the form is ready for release, the Supreme Court will put it out there far and wide. We will absolutely have it available for download on our website. I'm sure that a lot of prosecutors' offices, law enforcement agencies, and courts will also have the form posted on their websites. So I would say that when the form is completed, I'm sure it will be widely available.
Okay, and do officers and prosecutors have to give victims a hard copy of the form?
So that's an interesting question. There's nothing in the revised code that dictates what this looks like in terms of whether this is a paper document or whether this is, something where you're filling out something on an iPad and emailing a copy of it to the victim. I think either one of those things can work. And actually, in the other states that we've kind of based this process off of, because, let's be honest, we didn't make this up. We just very blatantly stole this from other states like Arizona, where they've actually been doing this since 1990, which is upsetting that we haven't, right? But in some states, they have a form that's in like quadruplicate, and you have to push really hard to make sure it comes all the way through on the fourth copy. And in other states, they're doing this electronically. So I think that it could be, an agency by agency type decision of, do we have the technology? How are we going to roll this out? You may see it in paper some places and digitally other places. So I think that it's certainly, there's nothing that dictates what this has to look like formatting wise. Not formatting, that's not right. What it has to look like physically. So it's going to be a policies and procedures by office type thing.
Okay, another question is checkbox regarding who was form provided by. What if the prosecutor's office designates this process to a community-based advocacy agency?
Yeah, so if you're a prosecutor's designee, then you're acting on behalf of the prosecutor. So you would check prosecutor, right? And if you are a prosecutor's designee, then, make sure they pay you. No, I'm just kidding, but kind of not. So just to be clear, right, like you would have to agree to be designated as the agency to perform this service, because the revised code does require that the prosecutor's office perform it or law enforcement at the end of the day. So the legislation, I think, is very, very clear about who has the ultimate obligation, but some prosecutors' offices do kind of designate folks that they're working with to perform services for them. And that's okay.
Thank you.
Thank you so much, Sierra and Elizabeth. All right, so on the next slide, this is even more information that is still on this form. So it's also going to have a signature line for victim and the law enforcement officer / prosecutor / custodial agency to basically sign right there. They're going to have a statement of right to counsel, so letting them know that victims have a right to an attorney, a link to the Ohio Attorney General's office pamphlet. So before, they were supposed to be giving out the little blue books, but those are, they're pretty big. And we were also finding out that law enforcement sometimes was not handing those out. So now they're actually going to have a link. They're going to have it on their website so that victims can find that and go to that and basically get more information at that point. Notice of victim responsibility to keep address up to date. So that's huge too, because we've had victims in the past that say they haven't been notified of what's been going on, but then they tell us, I relocated or I got a new phone number, whatever it may be, but they didn't update law enforcement or they didn't update the prosecution. So it is telling them, that is your responsibility to update people on your address or phone number. Statement that victim identifying information on the form is not public record. Victims can always access an unredacted copy of their own form. Prosecutor also gets the unredacted copy. And then the defense gets the form with the exception of the victim and representative contact information. So all of those things important to keep in mind. If you have any further questions, by all means, you guys can keep chugging along and asking us. And then, so
Hey,
on the
Bree,
back, yeah,
before we dive into the informational pages of the form, I think we should maybe just take our break because it's 10:16.
love it. I love it. That sounds great. I gotta refill up my water, so I love that.
All right, so we're gonna take a break until let's say 10:32 because it's almost 10:17 at this point. So I hope everyone gets some caffeine and sugar and comes back because as Bree said, the second half of this presentation is all the fun new information.
Can't wait. We'll see you guys soon.
All right, everyone, welcome back. We are going to pick back up where we left off just a couple minutes ago with our continued conversation about this form. I know it's a lot of information, so thank you for sticking with us on this. And I'm not going to forget, Bree, don't worry, that it's now time for our second attorney check-in. So if you are an attorney who's seeking CLEs, please put your name and your Supreme Court number into the chat now, and we will continue.
Perfect. So before we go into that, never mind. Someone answered the question already in the Q&A, so never mind. Perfect. Thanks, Elizabeth. All right. So now continuing on with the victim's rights request form. So now on the back of the form, all of this information that you see on the slide is going to be on the back of that form. So this is really awesome because it's basically giving victims all the information about what their rights are, whether they need to be requested or whether they're automatic. Provides information about victims' representatives, discusses the importance of arraignment. So like Elizabeth touched on before, if they want to get a stay away order, a criminal protection order, if they want to speak on bond conditions, those are some of the things that happened at arraignment, and it's very, very important if they want to be there. So on the back of the form, it will discuss that. The right to refuse defense interview, deposition, and discovery requests. Discusses those protection orders, compensation and restitution, the Safe at Home program, and discusses Vine. So very important information that victims should know about immediately is going to be on the back of the form. So that is the form in general. And then in addition to that, there's going to be an informational card, which is going to be, I think, attached to the form, right, Elizabeth? Okay.
I think it's probably a business card, at least how I'm picturing it, but there is some ability of law enforcement and the AG's office to determine exactly what this is going to look like. This is going to be created by the Attorney General's office.
Awesome. Yeah, and on this card, it's going to have all the rights that we're discussing right now, reference to the form, the link to that pamphlet that we talked about, the through the Attorney General's office, well, the site, the link to it, and then all of our contact information. So that toolkit as well will be on there. In addition, go ahead. Oh, okay. So now
I think that you stole my slide, but that's okay.
I'm sorry. Yep.
No, you were on a roll. You were on a roll. It's totally fine. So basically, when you're conceptualizing this, you have the victim's rights form with the whole point of that form to be some, again, broad information about some critical pieces, privacy, representatives, arraignment, services that are going to be applicable to a lot of victims. And then in addition to that, the probably business card, I think, is what is contemplated by informational card. And then on top of that, there's some additional information that victims are going to be entitled to. And this information traditionally is what we're thinking of when we think of, Val, you just called it the blue book. Yeah, crime victims' rights in Ohio, the pamphlet that's created by the Attorney General's office. So the additional information that victims are going to continue to get is going to be the information that we think traditionally is contained in that pamphlet. And the concerns about availability of the pamphlet will be decreased, I hope, by the fact that the pamphlet is going online. So the Attorney General's office is going to take all of this information and they're going to put it onto their website in a way that is easily accessible to victims. And then if you have a victim who, for whatever reason, does not have internet access, then they also have to be offered a paper version of this information. But for a lot of victims who do have internet access, it's going to be a link as opposed to law enforcement carrying around boxes and boxes and boxes of their favorite blue pamphlets. So that link is going to contain information about victim services programs, the compensation program, emergency shelter, and it's going to have some specific local information for those victims as well. So this will be very tailored to where the victim is for some of these things. For other things like compensation, Vine and things like that, of course, those cover the entire state. But you're also going to have some detailed local information. You're going to get the police report number, the business phone number, so the law enforcement agency's number, the information about who is investigating the case, who is potentially prosecuting the case when that information is available. All of that will be a part of this. Like I said, it will be accessed online through a link that is included on the informational card, and that a victim can have a printed version of that if they don't have access to the internet. So who gets this form? Basically, if you are identified as a victim on the police report, you are entitled to the form, right? So that's when you cast your mind back to the beginning of the presentation, when we talked about the victim definition, and we talked about the person against whom the criminal offense is committed. That person is victim on the incident report, right? Or on the police report. That person is absolutely going to get all of this information. But then in addition, anyone who, remember, affirmatively identifies themselves as being directly and proximately harmed is also entitled to this information. So now that we've talked about the contents of the form, the contents of the card, and the contents of the pamphlet, we're going to dive into the process. So this is kind of like, I made a flow chart for our staff here. And it's like this, it's not very pretty, but it's basically like, this is how this form moves through the criminal justice process. And it can be incredibly helpful to have a visualization like that. So I'm going to try to create a verbal visualization for you so that you understand. So first contact with law enforcement, victim gets the form, right? We all know that. Victim reports the crime, law enforcement responds. Law enforcement is prompting them to complete the form and make their elections as to which rights they want to exercise. If the defendant is arrested, so take, for instance, a domestic violence case where by law enforcement is supposed to arrest the defendant, take them out of the house. If the defendant is arrested and taken to a custodial agency, usually a local jail, the form goes to the custodial agency. So law enforcement transmits that form to the custodial agency. Why is that important? Because one of the rights that is upon request for a victim is the right to notice of release or escape of the defendant. So we know that most defendants, rightly so, are not going to be held pre-trial. They're going to be released with certain conditions at arraignment. But we also know that it's critically important for victim safety that they know if and when this person is going to be released so that they can take whatever steps are necessary to ensure that they're safe, right? So when this form is transmitted and the victim is checked, yes, I want to know when the person is released. Now the custodial agency knows who the victim is. They know that the victim wants to know about release, and they have the victim's contact information so that they can effectuate that notice. If the defendant is not arrested, so the defendant's cited and released, the law enforcement agency is going to talk to the victim about how arraignment is likely to work and how to get additional information from the clerk of courts about the arraignment in that case. It's Latina.
Hi. So since it's your flow chart, one of the questions is, can we get a copy of the flow chart?
I will happily share a copy of the flow chart with you. I mean, we could send it probably to like everybody through Eventbrite. I don't know if everyone wants their email spammed, but if you want a copy of any of the things that we talk about here, feel free to just shoot us an email and we will send you a copy of anything that you're interested in that we have.
And then one more question, since I'm on here, is who is going to be responsible for disseminating this information to law enforcement so that they know they need to be doing these things?
So in terms of disseminating the information, okay, let me answer both of, I think that could be two questions. I'm going to try to answer them both. If you're asking me who is going to disseminate the form to law enforcement, that's being created by the Supreme Court and will be disseminated by the Supreme Court. If you're asking me who's going to tell law enforcement about the new laws that they need to be following, Probably us, probably the Attorney General's office, probably the Supreme Court. I'm sure that there's going to be just a ton of training that's available. For instance, for those of you who haven't done training with us in the past, we're absolutely happy to come to different law enforcement agencies, prosecutors' offices, courts around the state, and talk to them specifically, maybe more of a conversation and less of a talking at you webinar, about their obligations under House Bill 343. So when the Marsy's Law Amendment passed, I did 90 some trainings in 2 years, and we're happy to do that again. And now it won't be just me, and I can send out all of the beautiful faces that you see on this training to come and talk with you. So their information is absolutely going to be available. Happy to walk anyone through obligations under this bill. And I'm sure that other agencies will be doing that as well. So hopefully I've answered both of what I think potentially could have been the questions.
And then one more question, because I know I haven't seen the form, but is there a line item on the VRR form that allows for indication of the victim's primary language if it's not English?
That's a great question. And no, there's not. Well, actually, maybe I can't remember if there is or not. You know what? I'll have to defer to the Supreme Court because they've added some things that actually go above and beyond what's required by House Bill 343. And I actually think that maybe something like that was added. But what I would say to go back to that, because again, I'm not creating the form either. Thank you very much, Supreme Court. So what I would say is, we have this right that Bree talked about way back in the beginning of the law enforcement conversation to interpretation services. So either the form is going to be produced in other languages, or, we'll have it translated on demand into other languages, or interpretation services will have to be provided to walk the victim through what we're asking them to fill out. So one or both of those things are going to happen because this House Bill 343 and these changes to the victim's rights require that there's effective communication.
Thank you.
Mm-hmm. So if the victim, hopefully not, if the defendant is cited and released, law enforcement has to tell them about arraignment and how to get additional information. We know that if someone is arrested, the arraignment is going to come up very quickly. But if someone is not arrested, there can be, more time in between the reporting of the offense and the arraignment. So it's important that victims get that contact information so that they can reach out and figure out what they need to do in order to be present at the arraignment. So still talking about the forms process here, once charges are filed, so once law enforcement or the prosecutor has decided that the case is going to move forward, law enforcement submits the entire investigatory file, including the VRR form, to the prosecutor's office. And if you're in a jurisdiction where law enforcement files charges directly with the court, then the law enforcement officer who's filing the complaint and the affidavit will submit the victim's rights request form to the court. So whether you have law enforcement filing the charges or the case being forwarded to the prosecutor's office for determination, the form is traveling toward court one way or the other from the law enforcement agency. And remember, the victim's name, identifying information, and contact information, including what is contained on this form, is not public record. So the people inside the criminal justice process are going to have access to the information that they need in order to effectuate these notices that the victim is opting into. But if the form, anything that would be publicly released, including the form, is not going to include the victim's name, contact information, and identifying information. An interesting little wrinkle is for businesses. Their businesses have the ability to blanket opt out of victims' rights. So for instance, say you have Walmart and, we're having prosecutions all the time for people stealing candy bars, which used to be 50 cents, but now they're $1.49. So that might move them up in theft offenses. I'm not sure. I feel like inflation is making every theft offense worse right now. So Walmart might not be super interested in getting repeated notifications about proceedings, being asked to fill out this form every time. They may or may not be interested in restitution, but essentially for businesses, they'll have the ability to say, hey, you know, this is the only thing I'm interested in regards to criminal cases. So you can tell me about this, but for everything else, please leave me alone so that I can just continue to do my job here. So as we talked about this right to privacy, and remember I told you about the case from the Supreme Court and how it was heartbreaking to me and I couldn't leave you hanging. So I wanted you to know that there was a provision in House Bill 343 that provides victims with the right to redaction. Now we're here. And we're going to talk about how it works functionally at the law enforcement phase. So this piece, I can't overstate how important it is to me for victims to have the ability to opt into privacy. All the victim has to do to get this redaction or removal of their name, identifying information, and contact information from the public records that are held by law enforcement is ask. So if they check the box, that's it. The VRR form enables them to do everything that they need to do to request the redaction. They just have to ask for it. Once it's requested, the law enforcement agency cannot release the records containing unredacted victim information. And in fact, there's a provision in the public records law that explicitly says these are no longer public records when the victim opts in. That's the end of it. So a thing to bear in mind about redaction, and that was definitely brought to our attention when we were working on this language years and years ago, is that there are some risks that victims may face when things are redacted from public record. And one of those risks is that it can be more difficult for law enforcement and prosecutors to determine that you were a victim of a previous crime. So for some of our crimes like domestic violence, protection order violations, menacing type crimes, there's kind of like a graduated system of, you know, maybe originally this is a misdemeanor, it becomes a felony 5, it becomes a felony 4, it becomes a felony 3. And so if we can demonstrate that this was the same victim over and over again, what we need to realize and what victims need to realize, what we all need to realize, is that there's no super secret database where prosecutors and law enforcement can access unredacted information from other jurisdictions. So they may have access to unredacted information from their jurisdiction, but they may not have access to unredacted information from other jurisdictions. So when they are charging, they might just be pulling public records off of, you know, a court's website, just like we do here at OCBJC. So knowing that there's no super secret unredacted database, it can make charging those graduated offenses more challenging for prosecutors. So victims will be advised of that potential risk, and they will get to make the informed decision about whether the redaction is worth it to them or not. But we do think it's important, always important, to give people all of the information, all of the tools that they need to make the decision that's best for them. All right, so now we're shifting gears finally away from the form. And this is a new right relative to inactive cases, sometimes called cold cases, which just says, hey, victims should be getting periodic notifications about whether a cold case is being reopened, whether it's being closed. Of course, victims have the right to get updates and to information about their rights and what's going on in their cases anyway. But affirmatively, if something dramatic is changing with the cold case, the victim should know about that.
Within reasonable time after arrest, a victim has a right to notice of all the things that we see on the slide. So the arrest of the defendant's name, the defendant may, whether the defendant is eligible for release, the phone number of law enforcement, right to call the custodial agency to request notice of release, the right to notice of terms of pretrial release, information about arraignment, and then the pickup radius of the law enforcement agency if the defendant is picked up elsewhere. So the last point's important because victims might think a law enforcement agency is going to go pick up the defendant, but it might be outside of their pickup radius. So in fact, they're not going to do that. So it's just important to walk that through the victim so that they're aware of that. If a victim that is holding a defendant knows which law enforcement agency is investigating the case, the jail must inform the law enforcement agency that the defendant is in their custody. So this can basically help, if someone has custody of the defendant and the investigating agency, might want to pick up that defendant, they can kind of work together to make sure that defendant stays in custody. Now we're going to dive into the prosecution portion of things and the right to participate. So this is also very exciting. House Bill 343 expanded this provision, and now victims cannot be fired or punished for attending any or all court hearings pursuant to their case. So this includes meetings with law enforcement or CPO hearings as well. If their employer tries to punish them, their employer will actually be held in contempt of court. So we love that because we want victims to have the right to participate in their court case, as they should. So that's a really awesome one. And then the process of the victim's rights request form. So just another point, which I know we touched on this already, but until the prosecutor actually gets a victim response, the victim is opted in. Within 7 days of the initial prosecution, if law enforcement provided a completed form, the prosecutor must file the form with the court. So again, like Elizabeth touched on, that form really travels with the victim throughout the whole entire case, no matter where it's at. And then if law enforcement did not provide a form, the prosecutor must send one to the victim within 14 days. So important to keep that in mind going forward too.
Yeah, and so the redaction piece, of course, still applies here as well with regard to the prosecutor's office, and it works in the exact same way that it worked at the law enforcement phase, which is for the prosecutor's records. If the victim just checks the box, I want my name, identifying information, contact information redacted from public record, the victim has the right to have that redaction. And again, that same warning that we discussed that is going to be provided to the victims at the law enforcement stage is also going to be provided to the victims here. So anytime they have the option to elect redaction, they're going to get that warning so that they can make the best decision for them. I did notice in the chat, someone asked a question about how redaction would work for child victims. So this is what I would say about that, and this is applicable for this entire training. When the Constitution talks about victims, it doesn't say victims who are, victim is someone who is over the age of 18. A victim and all of these rights that are attendant to that status can be a minor, which means that a child can, on their own behalf, opt into these rights. Potentially if they have a non-offending parent who is acting as a representative, that person can opt into those rights, including redaction for them as well. Now, remember too, like the victim can change their mind at any time. So if they want redaction today, and then they think about it more and they say, you know what, I would rather not roll the dice on prosecutors not being able to find this in the future. I don't want redaction anymore. They can change their minds at any time. And that's a critical thing that they're advised of in this form every time they look at it, that they have the ability to change their minds. So if a minor victim is opted into something, and then when they become an adult, they decide they don't want that, they can certainly opt out of it as well. So that's just something to keep in mind. Oh, hey, Latina.
Hey, I have just one question. I think I know the answer, but I just want to make sure with you is when the prosecutor files the form with the court, does this become part of the clerk's file on the case? So I'm assuming it does become a file on the clerk's file, but it's just not public record.
Yes, exactly. The form is a part of the file. The victim name, identifying information, and contact information remains non-public.
Okay, thank you.
Absolutely. So it works a little bit differently when it comes to the courts. So with the prosecutor and law enforcement, the records that they hold, it's just a checking a box. With courts, there has to be a filing that requests redaction. That filing is taken by the court under seal, which means that it's not public. The request itself is not public. So this is just a request that's made in writing with the clerk of courts directly, and no records can be released while the court is approving the request. So again, you have the right to redaction, but with the court itself, it works a little bit differently. We want to have something on the record, essentially, that shows where the victim went in and made that request. So this is something that was kind of ironed out as a process when we were working with law enforcement, prosecutors, and courts, and trying to iron out the fine details of what this would look like for every different type of request. So this isn't something where it's a super complicated motion where you have to make a legal argument or anything like that. But it is something that has to be submitted in writing to the clerk of courts. And again, it's under seal, so it's private. And then the court will basically approve the request, and then the redaction will be available going forward. And so, as I've said kind of throughout this, and I think that this is critical to remember, and we got a question that got at this early on about law enforcement and how reports would be made. Public offices under the statute have a right to maintain unredacted records for their own use, right? Like, of course, you don't have to write Jane Doe on every single thing, and that would make it incredibly difficult to prosecute cases too. So we're just talking about redacting that information, blacking it out, removing it before it's publicly released. We also have a provision in there that explicitly says that the victim has the right to their own records without the redactions that are related to them, and that releasing that information to the victim doesn't waive the protection for anyone else. So traditionally, when you actually dig into public records law, the way that it works is once something is released, it's no longer protected. So we explicitly put a provision in that said, even when this is released to the victim unredacted, it's still protected. So the redaction would still apply to folks other than the victim who wanted access to these records.
All right, so we're going to do another poll question. We'll give you guys a minute or so to answer this, and then we'll talk about it. Okay, so 99% of people said a professional advocate, 78% said a victim's family member, 73% said a victim's friend, and then 73% said a victim's significant other. So the answer here is actually all of them. So victims can choose any representative that they want going through the process. This person can be a professional advocate, a family member, a friend, a spouse. The only person that it cannot be is the offender. For example, in a domestic violence case, the defendant cannot be the victim's representative. That would be, of course, very, very problematic for the case. A victim representative can exercise rights instead of a victim or alongside the victim. This is very powerful because a victim can say they do not want to be involved at all in the case and can appoint someone else as a representative for that person to go to the hearings, to get notifications, to get information for them. Or it could also allow a victim representative to get the case information along with the victim. so that they don't have to do it alone.
Hey, Bree, we have a Q&A question, and it was just, since the court request is a different process, do we have a sample motion? We don't yet, and I'm not sure if it will be something that comes from us or if it will be something that's actually provided by the clerks. So stay tuned, it's kind of like a developing conversation. The clerks may have a form that they want victims to utilize. But essentially all the revised code requires is a written request. So it doesn't have to be anything fancy. It's simply a written request that's filed. It could be, on a piece of paper with a pen if you were complying with the actual language of the law.
Awesome, thank you. So continuing with the right to a representative, victims can choose, each victim is entitled to only one representative. So if more than one person seeks to act as a representative, like I know we had someone in the past say that I think 5 family members wanted to be a representative for that victim. So this is stating the court has to choose one, because that could be problematic. They could all want different things for the victim. It could just be a lot. So representatives who are not acting in the victim's best interest may be removed and replaced. So this is also in addition with the passage of House Bill 343. So prosecutors or the court can initiate the removal of this. But they have to make a showing by preponderance of the evidence to say that this person is not acting in the best interest of the victim. And then the court may replace a representative with a CASA, a GAL, or an advocate. And then this slide we love to talk about, and sometimes it's a little awkward when like us advocates are talking about it because we're obviously biased. But we just like to make a huge shout out to all the advocates on the call. Being an advocate is not always easy. It's a lot, and you're dealing with a lot of trauma, handling victims immediately after the math of being in trauma. And so I know here we are the first people that are kind of walking the victims through the process, explaining their rights, getting them the resources, doing anything that we can do to make them feel comfortable and heard. So it's not an easy job, and we just really like to shout out all the advocates that do this work because we appreciate you greatly.
Sorry about that. I was in the middle of typing out an answer to a Q&A, but I think what I will do instead is I'll just go ahead and answer it live. So the question was, if anyone can be advocate for the victim, does it have to be noted in the court in writing? So I want to clarify, we're talking about victim representatives, which is a little bit different than a victim advocate. When we think of a victim advocate, we're usually talking about someone who volunteers or is employed by the prosecutor's office or a community-based organization to provide advocacy services, versus a representative, which could be a family member, a friend, a significant other, a professional advocate, could be anyone. So while the law doesn't require that you let the court know in writing who your representative is, it's definitely a best practice. We've actually had scenarios in the past where people who have posed as victim representatives who actually were, once was like the wife of the defendant. So it's always better that if you're going to have a representative, make the court, the prosecutor, the law enforcement officer that you're working with, everyone aware of who that person is, so that information isn't inadvertently shared that shouldn't be shared with someone who is posing as a representative. And it's also good just to have that piece of writing to demonstrate that you did in fact appoint this person, that they accepted the appointment as representative, and that, everyone is on the same page with that, so that you don't have any notification issues going forward. Hi, Sierra.
Hello again. We had a question. So is it possible that later on in the case, can they add an advocate? So like when you first get it, when you put your victim representative, can you add someone on later?
Yeah, so again, there's a difference between a representative and an advocate. You're only allowed to have one representative. You could replace that person though. I could say, Bree, I want you to be my advocate. Just kidding. I'm sorry. Geez, now I said advocate. Bree, I want you to be my representative. Just kidding. You're fired. I want Sierra to be my representative now. If I was like a really fickle friend like that, I could do that in those 2 seconds, just like that. So a victim can always sub out, replace, or, get rid of the representative altogether, and they could just act on their own behalf. An advocate can act as a representative. So it's like one of those confusing Venn diagrams where it's like some representatives might be advocates, but not all advocates are representatives type thing. So you can have, and there it's actually provided for, and we'll talk about this later on, both an advocate and a representative at certain stages of the process. And that's contemplated, like I said, because your representative may be a friend or a family member, whereas your advocate is more likely to be a professional who is affiliated with the court system or the prosecutor's office or a community-based organization.
Okay, and so generally speaking, is the victim representative only available in criminal cases? What about civil cases? Also, are the representatives allowed in court with the victim?
Okay, so 2 separate questions. Representatives, so 2930 deals with the criminal and juvenile justice processes, and the right to a representative that we're talking about under 2930-02 is in the criminal case. However, this is a big however and a fun one. There's a constitutional provision that says victims have the right to exercise their rights through a lawful representative. Okay, follow me. And so it also talks about the fact that in any proceeding that involves the criminal offense, a victim can exercise their rights. Okay, so when I put those two together in my brain, which works probably differently than other people's brains, unfortunately for me, I think that if you're in a civil proceeding that involves the criminal offense, you could have a constitutional representative. So in your mind, just separate out the constitutional idea of a representative versus the legislative victim representative, which is, I think, pretty wholly designed to take part in criminal justice. So I think the answer is it depends. And if you want to talk more about that, sounds great. In terms of whether a representative has the right to be present with the victim, yes, they do, because both the Constitution and 2930-02 tell us that the victim's representative can exercise all the same rights as the victim. And since, as we're going to talk about, the victim has the right to be present, the representative has the right to be present as well. Okay, so diving back into advocacy and privacy, we love advocates, right? Like Bree said, absolutely no question, could not do my job, would not do my job, would refuse to do this work without Bree and Sierra and Alex and Morgan, our other advocates as well. So critically important, frankly, more important than I am by far in the criminal justice process. But unfortunately, in terms of protecting the information that's shared with advocates, Ohio law has not caught up to where I am emotionally with that, because conversations that victims have with victim advocates are not privileged, unlike conversations that they have with their attorneys. So the exception to that would be if your advocate is a social worker or a counselor who's acting in that capacity, then you would have a privilege. And privilege is really important because privilege is what protects people like doctors, lawyers, clerics, like your priest, all of us from having to testify or give the court information about what a victim has shared with us. So it's important for a victim to bear in mind that when you're working with, a lot of advocates, they may not offer that privilege. And sometimes advocates do get subpoenaed to be a part of court proceedings. And there are other arguments that you can utilize to try to prevent an advocate from having to testify about what a victim has said, but you'd rather not have to cross that bridge. So you have to be careful with that. And it's doubly true with system-based advocates, because if an advocate works for the prosecutor's office, remember when we talked about Brady versus Maryland and the obligation of the prosecutor to turn over all of the exculpatory evidence that they have to the defense? Well, that advocate that works for the prosecutor's office is under this umbrella, the Brady umbrella. And that means that they also, if they get any exculpatory information, they also have to turn that over to the defense. So it's very important to kind of bear in mind some of these limitations that we do have. And like I said, there are other arguments to prevent advocates from having to testify against, clients, victims. But you want to be careful with it. And it's something you obviously rather not go down that road if you don't have to. I'm talking, but I muted myself, but it's fine. It's totally normal. So anyway, this right here hasn't really changed very much from pre-House Bill 343. There's a little bit of new information that the prosecutor has to give the victim when the case starts. We do have a 14-day time frame. So within 14 days from the start of the prosecution, the prosecutor has to reach out to the victim and give them the VRR form. That's really important. So if the victim did not complete the VRR form with law enforcement, remember, if they didn't complete it, they've been opted in. But once the prosecution starts, if they don't complete it, they're opted out. So you have to affirmatively request your rights at the prosecution phase in order to get those rights. So it's really important that if you have a victim who was opted in by virtue of not completing the form, they get a second bite at that apple. Prosecutor also has to tell them what the offense is, who the defendant is, what the case information is, explain to them how the criminal justice process, which is CJP, works, and that victims have the right to be present at all of these hearings. Further, they have to give them a summary of the rights, give them information about what the victim can do if they're threatened, as well as who to contact in the prosecutor's office. When we talk about their rights, specific rights that apply at the prosecution phase that we're going to talk about, the right to a representative, the right to confer or discuss the case with the prosecutor, the right to legal representation to protect your rights, that's provided by the Constitution. Information about your rights that are automatic, and information about your rights that have to be requested. So all of that laundry list of information has to be provided to victims by the prosecutor's office within 14 days of the initiation of the prosecution. And then an additional little piece here that has been added is, if the victim asks for it, the prosecutor has to inform the victim of any defense requests that would have an impact on victim privacy or safety. So, for instance, if the prosecutor becomes aware of a subpoena for the victim's counseling records, the prosecutor would need to alert the victim that this request had been made. And this is really critical, actually, because when we look at the text of the Constitution, it talks about the purpose of Marsy's Law being to provide victims with due process. And due process just means that I have a right to know about things that implicate my rights so that I can attend and be heard when my rights are implicated. So in order to provide that due process, these types of notifications really are very critical.
So now with the right to notice, Marsy's Law provides victims the right to reasonable and timely notice of all proceedings upon request. This is from the Ohio Constitution, and on the next slide, we are going to talk a little bit more about what that time frame actually means, because before there was not a set time frame. So here, specifically, victims are not entitled to notice, or are entitled to notice within 7 days prior to a hearing, unless shorter notice is reasonable under the circumstances. So in the past, we have had victims reach out to us because they received notice of their court hearing, maybe the morning of the hearing or the night before, and they did not have time to coordinate around their schedules. So this provision states that victims are entitled to notice 7 days prior to the hearing. So that's really awesome too. And then here we talk a little bit about prosecutors and custodial agencies must attempt notice at least 3 times via either mail, phone, or email. These prosecutors and agencies must keep records of the attempts to notify, including receipt of the notice, the date of the notice, the manner of the attempt, the person who made the attempt, and then whether it was successful if they tried. We're very excited about this too, because now it's not just saying, okay, well, I reached out to the victim one time and it went right to voicemail and their voicemail was full. Now it's, okay, we're going to try 3 different times at least, and we're going to document everything. Records must be kept in such a way to permit public inspection while protecting contact information of victim and the representative as well.
So when we talk about this right to notice, and I'll give a shout out to Latina, who you've seen pop up with her lovely face multiple times, and I get excited because Bree and I just stare at each other for 4 hours otherwise. This was her case, and it's a fantastic case that really illustrates the importance of the right to notice, because in this case, we had a victim who, even though he had properly requested notice of all of the public proceedings in the case, he was not given notice of one hearing that ended up turning into, like I said at the beginning, a change of plea and a sentencing. And so because he was denied the right to notice, he was also denied the right to be present, the right to be heard, and the right to seek restitution. And the 8th District Court of Appeals held, when Latina appealed, that no, the failure to give notice made everything else that happened wrong. And now the court has to reopen sentencing to ensure that this victim has the right to be there, to be heard, and to request and receive any restitution that he proves he's entitled to. And so for me, when I think about these rights, I always tell people this, and it's probably annoying at this point, but I always think of them like dominoes, where if you never get the notification, then none of the other dominoes can fall. And that's a huge problem. So the right to notice is really important, and it's really important that victims know they have to request it. Because without it, you end up with a case like this, which is obviously incredibly problematic. So if you have a victim who is not receiving notifications of hearings, and we do this all the time, right? Like Bree, Sierra, you guys handle this all the time, where you're helping victims fill out a request for notifications to a prosecutor's office. In fact, when we first get a case, the first thing that we'll do if a victim is interested in receiving these notifications is, on their behalf, we'll help them fill out a letter requesting notice, providing the prosecutor with their best contact information, because it is so critically important. And the great thing, one of the many great things I think about the victim's rights request form is that in that first interaction, if the victim is in a place where they can make the election, or even if they're in a place where they can't, they are opting in to these notifications. So we have so many cases over the years where victims are never being told about their rights, and so they don't know that they have to opt into certain rights, and we end up with a really big mess. And I think that the VRR form is going to take us, hopefully, so far down the road from that. So I'm really excited about it. So per the Constitution, upon request, the prosecutor has to confer with the victim. What does that mean? Well, we have a bunch of slides to explain this to you. Essentially, in the new revised version of 2930-06, we have this process where the victim, in the victim's rights request form, can request to confer, right? It's one of the rights that's upon request. So they check the box that says, I want to confer with the prosecutor. And then when that form travels from law enforcement to the prosecutor to the court, now the court has a copy of this form, and the court knows that the victim wanted to confer with the prosecutor. So if we have a hearing that involves dismissing the case or amending the case, a plea, obviously before a trial or an adjudicatory hearing, if it's a juvenile case, or before diversion is granted, if any of those things are happening, and the VRR form tells the court that the victim requested to confer, the court is going to ask the prosecutor, did you confer with the victim? There's going to be a conversation, and the prosecutor will have to affirmatively tell the court, yes, I conferred. And maybe the prosecutor will say, and the victim is here and they want to say something, or and the victim is here and they're in agreement, or and the victim didn't want to be here, but this is where they stand with it. So if the court finds that reasonable efforts were made to confer, or reasonable efforts were not made, I'm sorry, to confer, then everything is put on hold. So if the victim requested to confer and the prosecutor doesn't convince the court that that conversation was appropriate, the court cannot rule on any issue that implicates the victim's rights. The court can't accept a plea and it can't impose a sentence. It has to continue the hearing for the time to allow that conferral to take place.
Now talking about the right to be present. So Marsy's law provides victims that they have the right to be present through any public proceeding. So this hasn't changed with the passage of House Bill 343, but it's important to keep in mind, because some people don't know this, that the grand jury is not a public proceeding. So victims are not entitled to be present there, but all other proceedings, victims have the right to be present at those court hearings. So victim and representatives have the right to be present during, again, any public proceeding except for grand jury. If present, victims may have support person, a victim representative, and a victim advocate with them. So we have seen multiple cases in the last year where victims were denied the right to be present in the courtroom for their own trial, where minor children were denied the right to have their parents in the courtroom while they testified, and where parents were denied the right to be a representative for their own child's case. So we hope that House Bill 343 helps to eliminate these scenarios so that this does not keep happening, because it's just terrible. So if a victim or representative are not present at a proceeding implicating the victim's rights, the court must ask the prosecutor if the victim requested notice, was the victim notified of the time, the place, and the purpose of the proceeding. The prosecutor then must disclose the attempts to provide that notice, whether the victim and representatives were advised of the right to be heard, and then also whether the victim and representative were conferred with. Also just oh yeah, go ahead.
We have a couple of questions.
Oh, perfect.
So they're actually relative to this slide, so I thought we would just take a moment. The first one is, our court does not notify victims of arraignments or bond review hearings. What's the best way to navigate this with the prosecutor's office? So in terms of courts providing notification of arraignment, well, first off, let me back up. Courts are not the main entity that's tasked with providing notifications. It's actually the prosecutor's office that provides these notifications. But in regards to arraignment, what we've come to realize is that prosecutors often don't have very much notice themselves, just by the virtue of how arraignments work, where arraignments can often happen very quickly after an arrest. So someone may be arrested tonight and arraigned tomorrow morning, and the prosecutor's office has very little notice as well. So essentially what we have kind of come to, and what other jurisdictions have come to in terms of what works best to ensure that victims have notification of arraignment, is for law enforcement to provide information about arraignment and contact information for the clerk of courts. So that's what I would suggest. In terms of bond review hearings, I think that, remember, victims have the right to be present at public proceedings. So if that is a public proceeding in your jurisdiction, and it wouldn't be everywhere, and that's why I'm saying this, the victim would have the right, if they requested notice of proceedings, and that request is going to happen very early now with the victim's rights request waiver form, the victim would have the right to be there. So that is pretty straightforward. If it's not, if the bond review hearing is not a public proceeding, that does change things. And we do have some provisions that we'll talk about here a little bit later that deal with basically ensuring that victims get notice that bond reconsideration is happening, or that, changes may be happening with things like bond or probation, but that if there's no public proceeding, there's no actual right to be present and heard, because that the public aspect of it is what triggers that right. So we have other questions that have come in while I was answering that one. If the defense requests separation of witnesses, does this apply to victims, or are they still allowed to be present in the courtroom? Mindy, great question. If the defense requests separation of witnesses, it does not apply to victims. And I think Bree is actually probably just about to touch on that. Evidence Rule 615 is the separation of witnesses rule in Ohio. It has an explicit exception for victims. So if you meet that victim definition, just like we've talked about, you have the right to be present, even if there's a separation of witnesses order, it doesn't apply to you. So that is very clear. And I think even in a case that we're probably about to talk about, State versus Montgomery, the Ohio Supreme Court has made it clear that victims have the right to be present. All right, Bree, I'm going to shut up.
You are fine. I appreciate you. So I think we covered everything on this slide. On the next slide, if timely notice was not given, inadequate information about proceeding was not given, or the prosecutor failed to confer, the court cannot rule on any of the issues that implicates victims' rights, accept a plea, impose a sentence, and shall continue for the time necessary to notify the victim. So this also basically comes into play if they say, okay, we have a hearing coming up on Monday, but it's just going to be a pretrial, nothing's going to happen. But then we find out later it's a change of plea hearing and the defendant is pleading guilty for a lesser charge. This is basically an example of that because they did not confer properly with the victim to let the victim be present and to basically state on the record whether they were okay with that or not. If a victim and representative are not present, the court may proceed if the prosecutor informs the court that the victim was notified of the time, the place, and the purpose of the hearing, which attempts were made to contact them. So how many attempts did they try to reach out to them, and then informs the court of the victim's position relevant to the proceedings. Victim and representative have the right. Oh, I think.
Sorry, Bree. I'm trying to multitask because we have more Q&As.
That's okay. No, go ahead. You can answer those ones.
All right. So wondering how to address situations where we would not have the official request from the victim to be kept informed. Hearing happens several years later. We don't have updated contact info, but we've tried to find it. We're unsuccessful. Yeah. So remember, and one of the things that the victims are informed of on the VRR form is that it is their responsibility to keep prosecutors' offices, courts, and post-conviction entities up to date with their contact information. So we definitely do not encourage prosecutors' offices to like send out an investigator to try to track down a victim. If you have tried with the contact information that you have, maybe you get like a return that says, hey, they're at a new address. It's reasonable at that point, I think, to try to mail it out to the new address. But really, it is the victim's responsibility to make sure that they are updating that contact information. So really, you don't have a violation if you're unable to contact someone because the information that you have for them is out of date. So the second question, what about a judicial release hearing that takes place when the victim wasn't aware and present, the judge already made a decision to release the defendant? Yeah, so that's a really tough one, right? Because a lot of times it's not going to happen that a defendant who has been released is being released. But with that said, we do have some provisions that we're going to talk about in terms of judicial release coming up that are designed to ensure that this hopefully doesn't happen. There are some kind of guards that have put in place because this issue has come up. And another question came in. Do victims have the right to file injunctions in regards to plea deals? I'm assuming no, since they're not a party. However, I just had a defense attorney tell me these sort of things are being filed. Yeah, I've never heard of that before, and I doubt that that's real. There's an injunction. I don't know what that means. Victims can file I know what an injunction is, but I don't know what that means in this context. Victims can file an objection to the plea deal. And victims can also come to a change of plea hearing, and they have the right to be heard regarding the plea. And sometimes that can be very compelling for a judge. And I have had cases where we have objected to a plea, which is the victim's right, and the judge has refused to accept the plea deal because it was, in that case, a very bad and dangerous deal for the victim. So victims do have the right to be heard regarding plea, but in terms of filing an injunction is basically asking the court to stop everything. So in terms of doing that, no, because as you said, 100% accurately, the victim is not a party. So putting a stop to something isn't in their wheelhouse, but objecting certainly is. The next question, are bond modifications public in Ohio? I have a very active client who was not present in pretrial. Bond was modified to remove EMU. Victim was not notified of the bond mod or removal until she called EMU to request info since he passed her home. How does the new House bill change or help this type of situation? So one of the things that victims are allowed to do, and again, we're, I think, on the verge of discussing this in the realm of safety and reasonable protection, is to file for bond modification if a defendant is violating, if the prosecutor is unwilling to file. And so I would say in that particular instance, and when we get there, Bree, we'll just cruise through this because now we're talking about it. So that's perfect. So I would say in that particular instance, the victim would be able to, while the EMU may have been removed, I'm sure that the defendant still isn't allowed to be near the victim. I'm guessing there's probably some type of restriction in place regarding that. So the victim would be able to actually make a request of the court to reinstate the EMU because now the defendant is coming to her house. Next question. Oh my God, we have 52 answered questions. We're doing great. If a notice is sent of a pretrial hearing and it ends up being a change of plea hearing, is that notice still adequate, or does the hearing need to be rescheduled so the victim is aware that there's now a change of plea? So I think it depends on how this has been explained to the victim, and this kind of goes back to why those initial conversations with the victim are so important. If the victim has been told that pretrials could turn into change of plea, and the victim has been told that there's a plea deal that's being discussed, I think at that point, that would be adequate to say that the victim understood the nature of the proceeding. However, if, as is so often the case, the victim has been told, oh, don't worry about pretrials, they're nothing, it's just a scheduling thing, don't take the time off work, you'll be bored, and now all of a sudden we have a change of plea, I think that that would be inadequately explaining this to the victim in terms of the nature of the proceedings, and that would be an issue.
Thank you. All right, so now back to the right to be present and heard. Victims and representative have the right to be heard orally, in writing, or both concerning the plea deal. They also have a right to elect not to be present at the plea hearing unless subpoenaed. And then a court cannot accept a plea unless the prosecutor tells the court they conferred with the victim, made reasonable efforts to notify the victim, discloses efforts to notify the victim, including the notice of terms of the plea, informs the court of any objections from the victim, and advises the court that the requirements of the revised code 2930 are met. So yeah, we've kind of touched on all of this. Then on the next slide, victims and representatives have the right to be present at arraignment, any hearing on release, any hearing to terminate probation or community control, and then any hearing to modify the terms of probation or community control.
So I would just throw out there, like, the key thing here is that there's a hearing, right? So when you're thinking about the right to be present, it always has to be triggered by a public proceeding. Now, there are times when people will tell me, our judge does this, and this hearing in chambers, and we never do have a public proceeding. That's kind of a different conversation, because ultimately these things should go on the record in some way, shape, or form. But remember, when we're thinking about, does the victim have the right to be here or not, the question is there a public proceeding? So as we already discussed, so we can kind of breeze through this, yay, separation of witnesses orders do not apply to victims, and this is the citation for that. We also have some case law, and I will not read this slide to you or any of my slides, but essentially suffice it to say that most courts in Ohio have embraced this standard that if a defendant wants to have a victim excluded from trial, the defendant has to present particularized evidence that fair trial will be violated. So this is not just an assertion that fair trial will be violated by the victim's presence, but that there's some particularized reason for that. The right to be present has been reaffirmed by the Ohio Supreme Court in a case called State versus Montgomery. Basically, in that case, the court said it goes a little bit too far to sit the victim at the prosecutor's table and identify the victim as the state's representative, but the victim absolutely has a right to be present, and no one is contesting that. So we have some really nice language from the Supreme Court on that issue. When we assert the right to be present, we always do it early. And now we've also learned that you have to do it often. So if you're helping a victim assert this right, as soon as you become involved in the case, you want to determine if the victim even potentially wants to be present, especially for trial. And then you want to go ahead and let the court know that the victim wants to be there. This is a right that constitutionally is supposed to be automatic, but it is also a right that is routinely challenged by courts, prosecutors, and defense attorneys. It's an equal opportunity challenged right. So absolutely let the folks in the criminal justice process know that you want to, or that the victim wants to assert this right, so that you can figure out if it's going to be a problem or not. And we just typically file a motion on it very early on from our perspective. So now we'll have a poll about the right to be heard and see where you are. I think we probably already had some spoilers at this point, but let's see who's been paying attention to this last 3 hours. Okay, so 71% of you said victims have the right to be heard before sentencing. I'm alarmed. 71% said before the court accepts a plea bargain. 67% said before the release of an offender. 65% said before disposition of the case, and 94% said anytime a victim's rights implicated. Okay, so I think that basically you guys were just like, you know what, it's all of the above, and I'm not going to check all of these, and that's what happened. And now I feel better. Thank you. Oh, I reshared. Sorry about that, Latina. That's my fault. Okay. So yes to all of those. So the Constitution says that the victim has the right to be heard in any public proceeding. So again, we have this triggering public proceeding that involves the release, check, plea, check, sentencing, yes, disposition, parole, or any time a victim's right is implicated. So I would say that a victim's right is implicated in all of these, and then this one is the catch-all at the very end, right? So just like the right to be present, we assert the right to be heard early and often to make sure that, you know, when a critical hearing comes, like the change of plea or the sentencing, the victim absolutely has the right to make their statement, and there's really no question at that point that could potentially hold things up. So this is a new provision, totally new provision under House Bill 343, and it deals with dismissed counts. So when I say dismissed counts, I'm talking about, let me give you a concrete example. Let's say that we have an indictment and we have a defendant who is accused of committing sex crimes against 5 children. Unfortunately common in our line of work. And let's say that, you know, let's say there are 5 counts of rape, which is a felony of the first degree. And of course, like many cases, you know, the prosecutor and defense are exploring a plea deal here. And so they decide, as a result of the negotiated plea, right? Not because the prosecutor has determined that they can't prove certain counts. Just to be clear, if the prosecutor determines that they can't prove certain counts, they need to just dismiss them, not dismiss them as a part of a plea. But if, as a part of the plea, the prosecutor decides, okay, we're going to dismiss 3 of these counts and the defendant is going to plead guilty to 2 of these counts. So basically what has happened is you initially had 5 victims and the prosecutor fully believes that they can prove beyond a reasonable doubt that there are 5 victims. But because most cases are resolved with a plea, we've decided that we're going to whittle this down to 2 victims. So that's the scenario that I'm referring to when I talk about dismissed counts. If that scenario comes up, those 3 victims whose counts have been dismissed can still exercise the right to be present, the right to notice, the right to be heard at sentencing, as if the counts had not been dismissed. The only exception to the rights that they can exercise is restitution. One of those 3 victims of the dismissed counts cannot get restitution unless the plea deal explicitly says that the defendant is agreeing to pay restitution for all 5 of the victims, right? Because we know from case law interpreting our restitution provisions and even case law interpreting the constitutional amendment's right to full and timely restitution, that restitution has to be tied to the criminal offense that the person is convicted of. So if we're going to have additional restitution paid, that has to be contemplated by the plea deal. But we're also preserving for those other 3 victims the rights to have their voice be a part of the case, even though their portion of the case was dismissed as a negotiation to get the case moving.
So this slide is in regards to safety. Victims are entitled or may be entitled to a criminal protection order, which is otherwise known as a TPO. This TPO is only in place for the duration of a criminal case, and it is different than a civil protection order. So keep that in mind when you're working with victims. Unreasonable delay. So this is one where prosecutors appreciate the assistance of our victims' rights attorneys here, because sometimes they don't want the case dragging on forever and ever either. But we can stand with the victim and object to those unreasonable delays. We also must set expectations for victims that a criminal case is not like Law and Order. Instead, we must set their expectation and explain that it is very common to take a year or 2 for a case to be fully resolved.
Sorry, I was once again in the Q&A having fun. So when we talk about delay in 2930-08, again, this is the provision that's going into effect April 6th. We have this new language that says courts should attempt to complete cases within the timeline set forth by the Supreme Court superintendent's rules. So basically, the superintendent's rules have these aspirational timelines for, minor misdemeanors, felony cases, and courts should be striving to complete cases within that time frame. Now, we know that doesn't always happen, and often there are good reasons for that. But courts should be striving to be within those guidelines. And victims do have the right to notice of the delay, right? So if victims object to delay, the court has to hear that objection. The court can only then grant a continuance for the time needed to serve the interest of justice. So when the parties establish that, okay, this delay is not just, for no reason, there's a good reason for it, and this is the amount of time that we need, the court will order it for that amount of time and no more. So when you are objecting to delay, this is something that always, for us, starts in the trial court. And in fact, that's a great point. You can't just go to the appeals courts. There has to be an assertion of the victim's rights in the trial court. So if the victim feels that there has been unreasonable delay, they want to raise that with the trial court judge. And we do that, of course, because we're a legal organization through the filing of a motion objecting to the delay. Now, if we continue to have delay and the court is ignoring that motion, then we can potentially contemplate an appellate action. And you would not do an appeal here because, as we'll talk about, an appeal would just cause more delay. So instead, you would file something called a complaint for an extraordinary writ in procedendo, where you're basically asking the appeals court to order the trial court to move forward with the case. Hey, Latina.
Hey, I have a question. The question is, do TPOs stay in place as long as the defendant is on probation or parole? And for those, I'm just assuming they're talking about for the criminal case, but in my mind, it has concluded. So I believe that once the case has concluded, that protection order is no longer valid.
Yeah, I think you're 100% right. And we talk about that later too. The protection order ends when the criminal case ends. But during the term of probation, there can be a no contact order, and there often is a no contact order, a post-conviction no contact order that's tied to the defendant's probation. So if the defendant has, jail time hanging over their head and they contact the victim, that would still be a probation violation, even though there's no longer an active protection order per se.
Thank you.
So now moving on to privacy, and this is the constitutional language, basically stating that except as authorized by Article 1, Section 10, which is the portion of the Ohio Constitution that deals with the defendant's constitutional rights, victims have the right to refuse interview requests from the defense, deposition requests from the defense, and discovery requests from the defense. So I know that we have like 40 minutes left because we've had so many questions, which has been phenomenal. So I'm not going to do my normal super long spiel on this, but I would just say that even prior to Marsy's Law, victims have always had the right to refuse interview requests. Depositions are incredibly rare in criminal cases. They don't show up at all in the same way that they do in civil cases. And so victims have, again, very seldom been deposed and almost never deposed at the request of the defense. And in terms of discovery requests, if you remember the initial conversation about Criminal Justice 101, where I said that discovery is the exchange of information between the state and the defense, of course, victims don't have to participate in that. And we're going to talk here in just a moment about this other process whereby defendants can obtain access to victim information, but there's a particular showing that they need to make that they're entitled to it. So on the question of the right to refuse discovery requests, we have a couple of cases, and this issue has been a really fun roller coaster since about 2018. But we have, for one thing, Ohio appeals courts split on the issue of whether a trial court has the actual judicial power to allow a criminal defendant to enter a victim's home as a part of discovery. So the first district said, no, we don't think so. And the 8th district said, yes, we do think so, in cases where, both cases, interpersonal relationships between the victim and the defendant asking to be given access to the victim's home to photograph, search. So the 8th district case actually went to the Supreme Court, and the Supreme Court said, courts have the power over discovery, but we're not sure if this is a proper exercise of the power. Bring this case back to us in another way, and then we'll talk about it. So we did. And the case went back to the 8th district. So that case went back again when the trial court issued another order that the defense could get access to the victim's home. And the 8th district basically said, maybe, the court has the power to grant the request, but the defendant has to make a showing of necessity based on particularized need. And we're talking about a pretty high showing here because we have to overcome all of these state and federal rights of the victim. So that's the context in which we've seen the right to refuse discovery request is actually access to a victim's home. Those are the cases that have actually gone up and been litigated to the Supreme Court and back. Now, when we talk about how you do get access to victim information, it's through a subpoena. And so basically, we have Criminal Rule 16, stay with me, which governs discovery, and Criminal Rule 17, which governs subpoenas. And subpoenas are the way that you get access to victim information or other third-party information if you're the defendant. So we have some safeguards put in place in the new legislation to ensure that victims are getting notified when their information is being subpoenaed, because believe it or not, it's very often that defendants subpoena information from counselors or hospitals or schools or landlords, and they don't actually notify the victim that they're seeking this information. And so the information just gets turned over. So if a defendant subpoenas victim information, the defendant has to serve the victim, the victim's attorney, and the prosecutor with notice that they're seeking this information. And the prosecutor will provide the contact information for the victim or the victim's counsel to the defendant to make sure that that service can be effected. In order to obtain any victim information, the defendant has to prove that they're entitled to that information or to those records. And there's a 4-part test. And it basically is just a test where the defendant demonstrates that they have a real reason to think that these records are going to be evidentiary. In other words, that they can introduce them at trial, that they're going to demonstrate something, versus what the Supreme Court has called a fishing expedition. You're not allowed to have a fishing expedition. You have to demonstrate that you're entitled to the records. And then if the defendant meets that 4-part test and the victim says, wait a minute, some of these records are privileged, then the court has to take the records in camera, which is just a private review by the judge, to determine which portions of the record are privileged and can't be released. So we have this kind of multi-step process that actually this case was set forth, or this standard was set forth by the Ohio Supreme Court, I think back in like 2001. So we've had this standard for a long time, and essentially just incorporated that standard into the revised code. On that same topic with subpoenas, this is for pretrial testimony. If a defendant wants a victim to testify pretrial, they have to make a showing of good cause. So definitely not the same heightened showing to get access to private records, but still there has to be some reason that the victim's testimony is necessary. All right, here we go. So now we're going to switch gears a little bit and talk about interviews and depositions. And this is a lot of text, but basically, first thing is, because we have a scenario that sometimes pops up where defense attorneys are contacting victims, but they're not identifying themselves as defense attorneys. And so victims are talking to them. So the prosecutor is going to tell the victim who the defense attorney is. If you're contacted by this person, this is who it is. The defense attorney has to affirmatively identify themselves to the victims too. We've had numerous cases where defense attorneys have said, I'm an officer of the court, and then the victim thinks that it's a court employee and starts talking to them. The court generally isn't going to call you. Of course, victims don't know that. If the victim wants to do an interview, they have to consent in writing. If they agree to an interview or deposition, they can set the terms and conditions, right? Like they can decide what they want that to look like. And if they stop the interview, that's fine. If they stop the deposition, though, they can no longer potentially use that deposition instead of trial testimony. So we do have rules that allow you to sometimes use depositions instead of testimony at trial. But if you stop it, then you can't do that. And then at trial, if the defendant tells the jury, the victim wouldn't even talk to me, then the court has to instruct the jury that that's okay, because the victim has a right to do that. So in practice, if you have a scenario where a defendant is seeking access to victim records, you kind of have to determine first, how are they trying to do this? Are they calling it discovery, or are they using a subpoena? And that's going to determine the approach that you take, because if a subpoena is filed and you file a motion to quash, it's quash, not squash. My mom says squash and she thinks it's really funny. She has this whole like giggle that she does when she says it, but it's wrong. It's quash. So just remember, don't be like my mom. And then if they're filing it under the discovery rule, your first step will be kind of to explain to the trial court why that's not proper, because victims don't have to be a part of discovery. And now Bree.
Thank you. So yes, going off of what Elizabeth said, victims and representatives also have the right to not testify as to what their address, phone number, place of work, or other locating information is, unless the court at that point determines that due process requires it. And they will actually determine that in a camera review to figure out if they need to give their information or not. On the next slide, if a prosecutor does not want to file a motion for bond reconsideration, we could do something like that. So we have done that in the past, even, just, going off of what the victim wants to do. Say, for instance, an offender wants to be released and they're harassing, intimidating, or threatening the victim. That's where we could come in, and Elizabeth, Latina, Chloe, they could file a motion in opposition to that. Now we're going to talk a little bit about CCTV and some of the new provisions in regards to that. So before the passage of House Bill 343, it's solely focused on victims under the age of 13. Now it expanded that to all child victims and victims with developmental disabilities. So this is a big expansion, which we're very excited about that. But this is also a very complex issue. So if any victim that is dealing with issues and they're arising from this specifically, definitely refer them to us and we can help out with that as well. And then on this slide, it explains a little bit about what other provisions are in place for victims. So in any proceeding in which a child or a person with a developmental disability testifies in open court, so say, for instance, CCTV is denied, they have the right to be asked questions in a way that they understand, to be free from harassment or intimidation, to have an advocate or representative present and within their field of vision, unless that person is removed. So like we talked about before, then obviously they would be removed from the court, to adjustments to the room to ensure comfort and protection for that victim, to have flexibility and informally to ensure, I'm sorry, I'm gonna widen this a little bit.
Flexibility, informality.
Thank you. To ensure comfort and protection. I really like this one, to have a comfort item. So some children in the past have wanted like teddy bears, those fidget spinners, they can have those on the stand with them now. This screen is also awesome, so that victims or witnesses do not have to see the defendant. I think that's going to come in handy a lot. To a secure and comfortable waiting area with a support person, and then to have an advocate or victim representative inform the court of the victim's needs. So a lot of information there, but it's really awesome. They also have a right to have standby counsel appointed to question them instead of a pro se defendant if the court finds a person would suffer serious emotional trauma if questioned by the pro se defendant. So yeah, keep that in mind too. If any attorney or party affiliated with the case discloses identifying information of a child victim or witness, they may be punished with contempt. We love this. Yeah, there's a lot of really good points here, but these are really exciting. So victims, attorneys, or prosecutors can also file motions asking the court to allow basically CCTV. So again, if you know of a victim that wants this, refer them to us, and if they're a child victim, come April 6th, refer them to us and we can definitely help out with that too. And then right to safety. So I know there was a question about this earlier. So we just highly recommend and suggest that courts have separate waiting areas for victims and offenders. There is enough trauma that victims go through already to just get to court. We do not want to re-traumatize them by putting them in the same area with an offender. So if it's a small courthouse and there's not accessibility to have two separate areas, then we can work together so that we figure out a way that victims and offenders do not have to be in the same area. So keep that in mind going forward too. And now we're going to go ahead and do another poll question.
Okay, so this is the rape shield question, essentially what evidence comes in regarding a victim's sexual history. Specifically, we're talking about trial, and specifically we're talking about rape and gross sexual imposition. So let's dive into that. This is fun. I enjoyed making this slide. I'm not going to lie. It's a little bit messy, but it's fun. So basically, what comes in? Sexual history with the defendant, right? So a lot of people think that it doesn't, but it actually does. Your sexual history with the defendant does come in, or the origin of semen, pregnancy, or a sexually transmitted disease. So the one change in House Bill 343 is that it used to just say origin of disease. We changed that to sexually transmitted disease or infection, actually, just to make it clear. I once had a case where a very creative defense attorney said that a victim's previous history of being raped should come in because it was the origin of her disease, which was that she was crazy, which was fun, kind of. No, it wasn't, actually. It was kind of a really insulting argument. But anyway, the judge thankfully was like, I think by disease, it means sexually transmitted disease. And then I was like, I totally agree with that. And let's change that law. So those are the exceptions, right? But then even for those exceptions, it also has to be material and more probative than prejudicial. So it has to be an actually important fact of the case for this information to come in. Any other previous sexual history of the victim doesn't come in, including a previous history of sexual assault. For rape shield matters, again, we say, file these early. In fact, you have to file 7 days in advance if you're the defense. If you want to try to bring in this type of information, you have to put the court, the prosecutor, and the victim on notice. Sometimes prosecutors will file in advance and say, hey, we know that you might think that you're going to talk about this, but we don't want you to talk about this. And they'll kind of get the ball rolling as well. Rape shield is really interesting because prior to Marsy's law, it was the one area of law where victims actually had the right to counsel, which we used to love, but now it's everywhere and we're just used to it.
Thank you. So within 7 days, victims must be notified. Oh, hi, Latina.
Hi, I'm about to say we have a question that is going to try to have Elizabeth answer.
I'm ready.
Are child witnesses included in the CCTV option when their parent is the primary victim? We have had many children as witnesses to abuse who are subpoenaed.
Yeah, so in terms of CCTV, it is specific to victims, but that's a great question, right? Because if you could argue that the child is directly and proximately harmed by the criminal offense, then I think that you have an argument that those rights do apply to them, because remember, we have this new expanded victim definition. So that's actually a really, really great point. We have never argued that. We have always had, the victim listed in the indictment being the victim that we're asserting that right for. But we would absolutely be interested in, trying to stretch that to accommodate child victims, especially if the facts make it clear that they would be directly and proximately harmed. So it's like, if your parent was robbed at gunpoint and you were in the back seat, yes, I think you're definitely directly and proximately harmed versus, something happening to your parent. Well, actually, you know what? I just convinced myself that almost always I think a child would be directly and proximately harmed, victim of an offense against their parents. So answer, yes.
Thank you.
Thanks, guys. So yeah, everything we see on this slide, I know we're running short on time, so I know this has been up, so hopefully you guys had a chance to see it, but basically 7 days, victims have to be notified of everything on here that you see. And again, we sent out the slide so you guys can go back and look at this stuff too. So now in regards to victim impact statements, and this is the pre-sentence investigation, I'm sorry, but probation must contact the victim to request a written victim impact statement to provide in the PSI. Basically, this victim impact statement is just really, really important for victims so that they have a chance to be heard about what their wishes are, what they would like for sentencing, how this has affected them. We have seen victim impact statements make a huge impact on what the judge actually sentences the defendant to. So we think it's great when victims want to do that. So if it's available to the defense, the prosecutor must also be given a copy. if any portion of the PSI is redacted, the court must explain this on the record as to why it was actually redacted. And if the defendant is not given a copy of the PSI, the victim will not be able to see the PSI either. So that's important to keep in mind too. Elizabeth, yeah.
This one is actually a change, because a lot of times every court kind of does PSIs a little bit differently, but essentially if you have a court that's sharing the PSI with the defendant, then the prosecutor and victim also are able to have access to it under this provision. But there's still a provision in this that says, you know, for confidential information, medical information, things like that about the defendant, that information can be redacted, and the court just has to let the prosecutor and the victim know that the information has been removed.
Perfect. Thank you. And then on this slide, everything is pretty much the same about victim impact statements, except the last bubble that you see on the right, the bottom right. So victim impact statements are not subject to cross-examination. So that is one of the things that was added because of House Bill 343 as well. So yeah, keep that in mind. And then restitution. So I know we talked a little bit about it when we were talking about compensation, but we just highly recommend that, again, victims know about restitution from the jump so that they can start collecting their restitution, keeping any credible evidence that they might have. So receipts, invoices, estimates, medical bills, and keeping that. And we can always help them basically make a packet to turn in to the prosecutor as well. But again, they can't double dip with that compensation if they were to get that too.
So we have some big changes for restitution in House Bill 343. Restitution was something that has always been like a little bit of a struggle because it is kind of intermixing some civil concepts into the criminal case. So there are some guardrails here for sure. For one, we have a list and including but not limited to list of the types of things that victims can get restitution for. So the value of your stolen or damaged property, medical expenses, counseling expenses, lost wages that are a result of the commission of the offense. The Ohio Supreme Court, as we'll talk about in a second, has said that victims are not entitled to lost wages for attending court proceedings. So that, unless I think if they were subpoenaed, it would be a different story, but for voluntarily attending court proceedings, you're not entitled to lost wages for that. And then we also have expenses related to making your home or your car accessible if you're permanently, partially, or fully disabled by the criminal offense. Hey, Latina.
Hey, just quick, well, maybe quickly. I just want to see if you have seen anything, but it's one of the questions is, does anyone do anything with victim impact statements on a not guilty to better serve the victim's mental health? So I don't know if you ever seen like some kind of outlet for that victim.
Yeah, if someone is acquitted, I think the issue that you have at that point is that it's been determined that there was no criminal offense, right? So if there's no criminal offense, there's no person against whom a criminal offense was committed. And so I think, you know, like a victim, like a victim defendant dialogue, or like restorative justice concepts, where a defendant might be interested in exploring that with a victim, and some courts I'm sure would be interested in facilitating that. But in terms of asserting it as a right, I think candidly, it would be a real struggle because now there's been a finding that there's no criminal offense and hence no victim.
Okay, thank you. And there's another question, but I'm not sure exactly what she means. So I don't know if you can understand. It says, if the judge will only order judgments for the restitution money.
So the restitution money, so the restitution order is both a part of the criminal sentence, but it also is a civil judgment. So basically, the victim is entitled under Marsy or under House Bill 343 to an automatic civil judgment. So it's as if they won a civil lawsuit. They can take all of the actions as if they had won a civil lawsuit to recover that money, but it's also a part of the sentencing. So if the defendant, for instance, is on probation, it could be a probation violation and not be paying your restitution. So it's basically dual in that way. I think that might answer the question.
Okay.
And
thank-
actually, that's what this slide is about.
Okay, thank you.
So I think the one thing that hasn't been said is that the Supreme Court is actually creating a form that will assist victims in understanding and requesting restitution. So we have had some Ohio appellate courts look at restitution in the early days of Marsy's law and its passage. We did complaints for writs of mandamus to protect victims' restitution rights. What we know now is that we actually need to file an appeal. So if a victim has a restitution issue, they're denied restitution, that needs to be appealed. We'll talk a little bit more about that. And as I said, the Supreme Court has held that lost wages and mileage incurred voluntarily attending court proceedings do not qualify for restitution. I'm trying to make sure I don't steal your slides, Bree. So yeah, Bree talked a little bit about this, but when we seek restitution, we usually file like a sentencing memo or some type of motion, laying out why the victim is entitled to restitution. And then we also itemize what the victim is asking for in terms of restitution. And I promise you that we're going to rush through this and we're going to give you about 5 minutes to do the post test and the evaluation. So what about juvenile courts? Well, you'll never know. We're not going to do this poll. I'm going to end it just in the interest of time. But I think it probably would be a hint to you that I've said delinquent act, that the rights in the Constitution and revised code do apply to juvenile courts. In terms of return of victim property, this is really untouched from the previous law. Victims have a right to have their property promptly returned. Police can do photographs in order to, be able to get the actual physical property back to the victim. After the case is over, the victim gets information about the appeal, including where the appellate proceedings, which let's be honest, we're talking about an oral argument, where that's taking place and what the result of the appeal is. It's important to explain the appellate process so victims know that appeals are normal. Bree?
All right. So post-conviction, if the defendant is convicted and sentenced to incarceration, the court must ask if the victim wishes to update their form. So just, again, it's following with them the whole time, and they're asked if they want to update any of what they marked on there originally. Upon request, victims are entitled to notice of any release or escape of the offender. So important to keep that in mind. Prosecutors must, upon request, they must notify victims of incarceration dates, information about ODRC and ODYS, and then hearings on judicial release. So again, if victims want to be present at that victim so that they can be heard, they can do that. The court must inform the prosecutor at least 7 days before the hearing. And I think we're good on that side, Elizabeth. And then on first contact with a victim, the custodial agency must verify the victim's choices in the VRR form. If no form was transmitted to the custodial agency, it must send one to the victim. Yep, so we're good. And then victims of violent felonies of the first, second, and third degree will automatically receive the notifications from DRC or DYS. And sometimes we tell victims anyways to just sign up for it because it's better to just make sure that they're getting informed of what's going on and notified of what's going on. And because it's better to be safe than sorry sometimes. So keeping that in mind. And then on the next slide, victims of the violent offenses will receive notice of the escape and recapture within 3 days, death within 30 days, and the DRC petition for early release within 30 days. So some of these things, like I know for me, I'm not going to remember exactly like 3 days, 14 days, 7 days, 30 days. So just the slides will be helpful. I know I'm going to print them out so that I can kind of go off of them. You guys might want to do the same.
So we have a new piece about the governor and pardons and commutations and just ensuring that a victim has a chance to give a written statement and when the governor is considering taking some type of executive action. In terms of judicial release specifically, I referenced this earlier, so I want to spend a moment on this. When a court is considering judicial release, it has to allow the victim and representative to be heard on that issue. So the defendant, if the victim submits something in writing regarding judicial release, the defendant gets a chance to review a copy of the statement. DRC and DYS get the statement. The court has to consider the statement. And if the court does order release, it has to promptly notify the prosecutor, and it has to send its entry ordering the release of the defendant to the custodial agency before release. Because what we found is that oftentimes when courts are releasing defendants, the custodial agency doesn't even know that the person was up for release. So there has been some communication breakdown in between courts and the custodial agencies, and we did attempt to tackle that with this legislation. So as we talked about in the prosecution section, the same thing applies here. When prosecutors and custodial agencies are doing post-conviction notices, they have to do the 3 attempts. They have to keep the records. The records have to be publicly available. Vine, of course, has existed. Nothing in House Bill 343 automatically registers victims for Vine. So victims still have to register for Vine. We can still register for Vine. Anyone can register for Vine. It remains an amazing resource, in addition to all of the wonderful notifications that DRC and DYS do. We talked about post-conviction no contact orders already as an option when you have someone who's not incarcerated, as a term of probation. So we have some additional notifications when you have things happening with probation that don't involve a public proceeding, and basically just ensuring that the victim or representative gets notice of any probation termination hearing, probation modification hearing, an arrest for a probation violation, or the failure of the defendant to complete diversion. So this is just notification of what's going on. If there's not a public proceeding, the right to be heard and present isn't triggered. So if in addition to that, other probation notifications, so if there's going to be a modification to the terms of probation that impact restitution, detention status, meaning that the person is incarcerated, or victim safety, the victim has the right to know about that. If there is a hearing, the victim has the right to be heard and present, of course. If there is information about the violation that led to revocation of probation, the victim has the right to know. And if there are changes to probation terms that are following a risk assessment that impact victim safety, the victim has the right to know. So we're really getting into the weeds and into the specifics of when a victim has the right to know about probation pieces. Also, in regards to sealing and expungement, these are public proceedings, but we did amend these statutes to ensure that anytime a defendant or juvenile offender is seeking sealing or expungement, that the victim is entitled to notice of that, that they have a right to be present and heard at those proceedings, that the court will consider the victim's statement, and that the victim will get notice of the ultimate outcome as well. So in terms of how a victim exercises their rights, the Constitution is still the same. They can do it themselves, through counsel, through a representative, through the prosecutor's office. But what we have big changes in is 293019 that talks about how this looks mechanically in trial courts and in appellate courts. So I'm going to spend the rest of our couple minutes on this. And then, as Sierra said in the chat, please hang tight, because if you're getting CLE credits or CEUs for the full time, we need you to do the evaluation and the post-test. But essentially, victims have standing, we knew this from the Constitution, to assert their rights. They can do that through their counsel, through the prosecutor's office upon request. If the trial court denies a victim's right, they have to, or if the trial court is taking up the issue of a victim's right, they have 10 days to do that. If they deny the victim's right, they have to issue an entry that clearly states their reasoning. So when you have victim counsel, the victim counsel has to get served the notices, motions, and court orders in the same manner as the prosecution and the defense, so that they know what's going on. They're also included in bench conferences, so private discussions, meetings in chambers, if victims' rights are implicated. Again, this doesn't make the victim a party to the case. They're not a party. This is just involvement when their rights are implicated. So if the trial court denies the victim's rights, the trial court has to give the victim a copy of the entry where the rights are denied and provide them with this statement, which I'm not going to read to you, but basically tells them that they have a very tight time frame to do an interlocutory appeal. So if the criminal case is still ongoing, the victim has a very tight time frame. They need to do this immediately, and kind of providing them some guidance. So if the victim appeals, they have 14 days to file the appeal if the trial court case is still ongoing. If the case is over, they have 30 days to file the appeal. If you have an interlocutory appeal, which is an appeal where the trial court case is still ongoing, the trial court has to submit everything to the appeals court in 5 days. The victim or state has 8 days to file their brief, which is very quick. The defendant or state has 8 days to file the opposing brief, and the Court of Appeals has 35 total days from the date that the appeal is filed to decide the case. So really, really tight timeframes for those of us who are going to be litigating these issues on appeal. If that appeal is the interlocutory appeal goes to the Supreme Court has 60 days from the time it's filed with them to decide the case. So again, really, really tight timeframes. Same thing with complaints for writs that are done in an interlocutory manner while the underlying case is still ongoing. 45 days to decide those. So again, this is happening much, much more quickly. We're used to appeals taking years, and now we're turning this into months. So it's going to be very aggressive scheduling. While these appeals are pending or writs are pending, speedy trial time is told during that time. There was a case in the Supreme Court that started in the second district where the court said that the second district said that a prosecutor can't exercise victims' rights on appeals. That was reversed by the Supreme Court. So right now, prosecutors have the ability to exercise the rights on appeal. Just like we just talked about in these new revised code sections, the Supreme Court has said that when the Constitution talks about victims petitioning to enforce their rights, that's broad enough to be an extraordinary writ or an appeal. And the Supreme Court has said that if victims want to challenge violations of their rights at sentencing, they have to do that with an appeal. They cannot use an extraordinary writ. It has to be a timely filed appeal. And we made it. And I gave you 5 minutes. I'm not a liar. Yay. So here's our contact information if you want to refer a case to us. Please go ahead and take the post test. As soon as most people have taken the post test, we'll give you about the same, like 3 minutes that you had originally. We will then populate the evaluation. While you're taking the post test, we just wanted to thank you so much for all of the questions. I knew that we were going to get questions. I didn't think that we would get 60 some questions, but I'm so glad that everyone was here with us and so engaged with us. I hope that after this, you guys have a plan like I do to have more caffeine and sugar and probably something more substantive than that for your lunch. But we just appreciate so much everyone being here, all of the wonderful questions. We hope that, if you have folks in your offices that weren't able to make it today, that they'll join us in the future. And, as we have less questions and this information gets more familiar, I probably won't have a mad dash at the very end, but no promises.
Just so everyone is aware, we're gonna go over the results for the post-test, and then after that, the survey is gonna pop up too. So just hold tight. It's not gonna be emailed to you. It's gonna come up just like the polls.
And yes, at the very end here, please, attorneys, do remember to submit your name and your Supreme Court number for our third and final check-in, as well as the post-test and the polls. And thank you again so much for joining us and for all of your kind words. We really, really appreciate all of you guys. Okay, Bree, take it away.
All right, so victims in Ohio have constitutional rights. True. So 99% of you got it right. Victims don't have rights until the case reaches the prosecution stage. False. Victims have rights initially. A victim is a party to the criminal case. Oh, some people still got that one wrong. It is false. Victims are not a party to the criminal case. It happens every training. It's okay. Victims have the right to be heard by the court anytime their rights are implicated. True. 99% of you guys got that right. That's awesome. Victims can be present for any public hearing unless the defendant objects. Then they are to be excluded. That is false. So 73% of you guys got that correct. The definition of victim can include parents of child victims and surviving family members. 100% got that right. Awesome, guys. That's great. All victims get notified automatically if an offender is going to be released from prison. No, that is false. It's the felony of the first, second, and third degree. In the Ohio Constitution of Ohio and Ohio Revised Code, a victim representative means a professional victim's advocate, attorney, but not victim family member or friends. That is false. No, it can be an advocate, family member, and or friends. If the defendant asks the victim for an interview before trial, the victim has to say yes. No, that is false. They do not have to agree to that. And then child victims have fewer rights than adult victims. That is also false. They have the same rights as adult victims. All right, so now the survey is gonna come out to you all. So if you guys would go ahead and finish that, that would be great. And as Elizabeth said, thank you all so much for joining us. We know this is a whole lot of information, but hopefully you learned a lot, and please, just give this information out to everyone, refer cases to us, and hopefully we will see you guys all soon in person.
And you're free, by the way, you're free to go once you've completed the satisfaction survey. We apologize for the additional moment or so of your time that we stole, but we really appreciate you being here with us.
Yes, and to answer Sheriff Happy's question, yes, I am the same person. I just got recently married, so my last name got changed, but that's me. I hope that's a good thing though. I guess I should add that in there too. Oh, I see why people are asking that. Makes sense. We need to update that. It's okay if you get the answer wrong.
I think you have to end the meeting, Bree.
Sorry, guys. Okay, I'm ending it. Bye. Have a great day, everyone.